Okay. I think I'm here. I've literally cut out every internet cable from my connection to find a way to run this entire thing wirelessly to see if anything that is wired is the problem. Can you hear me? Can you hear me? Let's see. Let's try this pop out again. I can hear you. Yes, we hear you loud and clear. Okay. So what I've done is I've eliminated my laptop from the feed. I've eliminated the... You guys have never seen this before. You guys have never seen this. This is my switcher. This has 211 buttons. They're not actually flashing in real life. They're LEDs, but they have a little diode in there that actually all LEDs do that turn on and off multiple times a second, but your eyes can't catch it. It saves power, saves the LED. So my camera catches it with the frame rate as it's catching pictures. But in real life, these stay constantly lit. Light emitting diode, yes, with the I forget what the name of the device is that makes it flicker, at least in cameras. Okay, so here's what we have. I'm running my switcher, but not as a streamer, so it's not streaming for me. I no longer have access to my buttons. My buttons do nothing over here. Doesn't matter what I do, so I have to run everything manually here, which is a little bit of an issue, but we'll get it figured out. No connection there.
There's a lawsuit.
Let's see. We might still be able to do this because I need to have... It might be a little messy at times. Let's put it that way. Need extra stress foods. Yeah, it's bugging me for some reason that I can't remember what the name of that. It's some sort of resistor or something that that turns the light on and off, 60 times a second on a LED. Okay. Anyway, are we back, Debbie? I think we're back. I'm still working on getting your chat on the screen. I can see it. The chat bot is running. I have to just maybe figure out a way to run my switcher through the computer. It's got a USB connection now, and it sees it. That's good. That's a start. I don't have an IP address because I'm not running through the internet. Okay, so we're good there. That means I can turn on this, but it'll look ugly until I make the go like that. There we go. So we've got chat. Okay, but it will get ugly every time I turn it off. You guys are amazing. I'm here. Let me get ready for court because holy cow, the internet is an issue. And for those of you who want to hear me complain about the internet and everything I've done to try to get this working, feel free to let me know. But now's a good time to see behind the scenes just a little bit. This is an ATEM Mini Extreme ISO. It's an 8-port HDMI switcher. It's a hardware switcher, so that if I wanted to change from, say, like the camera you see right now to my camera, I can just hit the button back and forth and do that over here. So I've got 8 different inputs, and all of those correspond to various things. Like you can see my olive chat if I do this. That's how I see it. So, yeah. So we are back a little bit. I don't know who has the internet. Golden Mom again. Back and forth we go. Round 2, Golden Mom. Not your fault. I've got a background in IT. Okay, let me just say this, and I'm going to hunt down this problem, and I'm going to find it. And the way you do that in IT is you start by checking the cheapest things first, and that would be the cables. So changing out the cables, we've switched everything to wireless. If the problem does not repeat itself when we're on wireless only, then I can eliminate. Then it's that's a good step. I cannot see how my stream is doing right now because the device that's doing the streaming, I've switched computers. So there's no load on my laptop whatsoever. So many toys. Not enough though, Sunshine Sunflowers. We're looking better here for now. Okay, this might be where we stay. Yeah, I've already switched out cables. It might be I've got a a gigabit switch that I run everything through. So it goes from my internet to the switch and then everything. That might have died or might be having issues. So we'll see. You try taking out the cartridge and blowing on it like the old Nintendo. That usually works. I should do that next. Do you have a certain recommendation for multi-port HDMI switcher for my TV and all my assorted electronics, mostly gaming? Sunshine Sunflowers. This is the most incredible device. This was a game changer. I've been using this for almost 2 years now. Every single live stream I've run through it, but I've always used it to live stream straight to the internet. You load your streaming key to it, and you're good to go. It has dual HDMI outputs. You can send different things to different destinations. Like if you want to have everything on a multi-viewer like I have, you can send that to one destination, or you can have just your program out to another, and you can completely switch it on the fly. It's fantastic. It's most of the things you can control through the control surface. What you can't, I'll just show you. It's like a behind the scenes day here today. Why am I not getting anything? Let's see. Come on. Let me show you what I've got. Let's go. It's going to look a little bit ugly, but this is it. So this is my switcher here. So I've got my media files. Yeah, I think I want to allow that. So all the media files I want to switch to. I've got my audio switchers as well, and all that. I can do that here. But holy cow, I just that was dumb. I need to stop and restart because of something stupid I did. I can't show you that anymore. So round 3, here's what I'm going to do. I'm going to line up the video from the courthouse for the Alex Jensen trial, where I'm going to stop and restart. I have to change my streaming key because I just publicized it, and that's a big no-no. Even though I'm not, well, actually I'm not. Here we go. I am not streaming right now using a streaming key, so I can change that here. Let's go to this. Okay. Yeah, that was stupid of me, but hey, that's I live and learn. Oh man, good day, good day. Okay, so what I'm going to do is I'm going to line up. I need a feed with. Let's do this one. Okay, I need.
There's a lawsuit.
Are we watching from WC? What was the name here? I'm on a different device here. So what was the name of the channel we were watching on? So I don't have to hunt for it again. We're going to get all the glitches out right now. KCRG, thank you. Okay, let's bring this in. Looks like they're just doing the preliminary jury instruction stuff. Oh, we've got a new camera angle. Okay, let's bring this on camera 7.
Essentially, my analysis as well, I agree that is, again, an argument that's appropriate to make by the defendant during closing argument, but not appropriate to include in instructions to the court and add the court's kind of stamp of approval on that argument. So
I'm not sure why.
What is true and what isn't true is going to be up to the jury to determine. All right. Any other issues?
No, Your Honor.
All right. So
that's not right.
Getting back to instruction number 10, again, I am going to add the word allegedly in that sentence that we already discussed.
This is super ugly, guys. I apologize.
And I am going to remove the word substantive as well. I do think that otherwise there's confusion about what's the difference between 10 and 13, and it's not clearly explained to the jury. And again, you guys are free to make arguments on this.
I need to move me manually
to the jury. So I'm going to make those 2 changes, take out the word substantive, add the word allegedly. I'm going to make no other changes to these. I'm going to go make those right now, print them off, and make copies for the jurors. Other than that, are you folks ready to go at 9 o'clock or thereabouts?
Yes, I want to run downstairs and grab something out of my office.
Probably going to be longer than 9 o'clock before we get the changes and copies, maybe around that time.
I don't think I need anything more than to change the, because we're only changing the page.
Yeah, I'll just make that one change and give you a new page, each of you a new page, and then we'll start with copies.
Can I give you these two for the record, Your Honor?
Why don't you just file them when you get back to your office?
All right.
Okay.
You did read them into the record, so I don't know if you actually need to file them again, but if you want
This
to,
is
that's your
live. This is
prerogative.
they're
Just
just
very
gone over the
proud of
jury
them,
instructions. They're waiting for the
All right.
jury.
Also, can we have a break between Ms. Slaughter's closing and ours to set up?
Yeah, I mean, I don't want to take a long break, and I guess we'll just see where we're at. But yes, I mean, obviously you'll need a few minutes to set up your stuff.
Thank
And
you, Your Honor.
all right, we're adjourned.
Okay, switching is going to be a little bit difficult, but we'll get this figured out. I need to turn on one more thing here. I need to keep my face showing, so that's this button right here. There we go. All right, good grief. I have reset my streaming key, so it's not going to be a problem that way.
There's a lawsuit.
Do we file those?
I don't know why we've got the view the way it is. Let's see if I can get this changed. It's just cropping it funny because it's coming from an iPad. Let's see. I'll keep working on it. It's kind of different camera angle. Yes, we get to see the defendant for the first time in a long time, which will be interesting. I'm glad they moved this. We're now looking basically as the jury sees, or close to how the jury sees, which is good. I appreciate all the kind words. I'm frustrated with myself that this isn't working, but we're gonna get through this. I'll figure it out. And if I have to replace some hardware, I'll replace some hardware, and it'll work. It's about time they showed his face. Yeah, we didn't get to see any reactions to anything he did all this whole while. So.
Well, if they're back at the office, we need them over here because they have to go back to the jury.
Okay, I have to plug in my Apple TV. I'm going to put that straight into my switcher, so give me a minute here. Okay, let's actually try one more.
I can do it. Where are they? Thank you.
Okay, we're going to go full screen now. Got a better feed right there. Yay. But now I'm gone. That's no good. Now I'm back. Okay. All right, we're slowly getting back to back to good. I'm frustrated that that it's working well right now. I would really like to blame the internet, but the idea that I might have to call the internet repair guy and apologize for all the unkind things I said about his parentage is not exciting. Is he squinting? Does he need glasses? I don't remember. Did he have glasses before? No, my switcher is now where my mug should be. The last thing I said in the last two previous streams were it's working now. So I won't say that on this one, AJ. I will tell you this. I have no idea how many people are here. I can't see that right now. Not sure why. Let's see. Oh, yes, I can. through the miracle of wirelessness. Okay, we've got a few people here. Thank you so much, actually, for being here. It makes me feel a little bit better. Makes you wonder, if he's sitting there thinking, what's the worst going to happen? I'm found guilty, and I actually am, or does he think that is he guilty and thinks he's going to get away, or is he not guilty and will be completely surprised if the jury finds him guilty? Interesting. Thank you, Sharon. I apologize that I have to do this live. I ran the test this morning and everything was beautiful, and it was all roses. The internet speed was fantastic, and as soon as I hit the live button, it drops down from the 37 that I'm supposed to have down to 2, and then we crashed. So I'm worried that it's my switcher. So I might be. I'm hoping it's just a reset that would fix it. Like it has something internally that's having problems.
IT fund, HDMI fund, Sarah Boone letter fund, etc.
Pickles on Politics, formerly TW. Thank you so much. I appreciate that. We'll get this fixed. We'll be back to our regular situation. I just have to do a lot of testing. So sleep won't happen for the next couple of days until we get this figured out. I was watching. I was just scrolling through some of the videos that have been posted by about BK in the last few days, by the way, and it said Law and Crime came out with one that said BK, met with 2 of the girls or went to the restaurant where they work or something, and it's just their big story like 2 days ago. And then yesterday their big story was restaurant owner debunks he debunks the story basically yesterday. Yesterday's story was a lie. That's what they said. So their source apparently wasn't very good because the restaurant owner did not agree. I'm making Recovery Addict a crash helmet for days like today. I might need it, but I think I have my fingers crossed right now. I'm optimistic. Okay. While this is going, I'm going to try to get my Apple TV to talk to my new network, which is why it was not working wirelessly. We'll get that fixed here. If I can remember the password, I'll share my password with all of you. How about that? That way, let's see. Network, here we go. Not working. All right, we'll have to do that later because I can't change my screen. Normally when we're live, I can change my big backdrop, this one over here. I can change that so that you're seeing, program out, what I want you guys to see, and I can do some changes in the background and get everything prepped. Can't do that right now because my buttons, my amazing button box, the Stream Deck is not working because nothing's connected to the network. So we'll get it fixed. I'm hoping it's not a result of pouring water on my laptop. That would be sad, but I should be able to run everything without the laptop. Let's see what we have here in chat. I'm missing my border today. I think the border is only an option I can get on. Let's see. Don't need this there. Okay. We're just not gonna tweak anything because it's working right now. How about that? We'll just sit here gently and don't touch any buttons. Somebody took my border. I think he's a little tired, but I think he's also got a sense of foreboding. No surprise that he didn't testify in his own defense. I don't think that would have gone well. he already did enough damage every time he talked to the police from the 911 call on. Yeah, the mods have been fantastic. Thank you so much. I appreciate that. Spreading information when I am down and where to go and what's happening. I appreciate all of you. Have I been putting SMB pickles in my Ethernet port? Why would I waste the pickles that way? Seems to solve most problems. Don't even blink. I'll just freeze and it'll keep working. Liquids and electronics aren't friends, but what if they need to be washed? Perhaps he's writing a letter to Sarah Boone. Dear Sarah, good morning, everyone. Do we have a verdict? Shutterbug, we're a little early for that. We're first going to have the jury instructions. The two sides met and started a little bit early and hammered out the last details on those. The judge is getting them ready. It's probably going to be a few more minutes before he comes in and has them all printed off and ready for the jury. Possibly, Richard. But once the judge comes back in, he's going to read the jury instructions. And I know it's sort of funny to do that where the judge goes in and saying, hey, now it's time to deliberate and everything. And then they have the closing arguments. But the judge wants to get the instructions out of the way. And that's actually pretty standard practice to have the jury instructions come first, then the closing arguments. It'll go prosecution first, and they're going to do like a shorter version. And then the defense gets their full time. Go last as well, sort of put a button on it, and they always do. They get the last word, and then the judge charges the jury, says, all right, go do it, out the door. Don't come back till you have a decision, basically. And that's what we get to. Is it buffering for anybody? Catlaw, did you say it was buffering? If it is buffering, yeah, we need the poll again. Sorry, there was a poll that I never got to close out. It's buffering a little. Okay, if it is buffering, then with all these tests I'm doing, that's actually a good thing, because that means that it's most likely not my switcher, which is the one of the most important expensive parts on my system. Glitched a bit. Okay, I'm going to run a quick speed test here and just see what's happening. I'm almost getting a full gigabit on the download. It'll buff out. Okay, I'm up above 30, so we should be good right now on the upload as well. And Laura says buffering. Will jury be sequestered during deliberations? Never heard of the judge said. I think he said they would. No, white screen. Can't hear you. Got better. Got worse. Sound is glitching. Okay, so I'm getting mixed results. Make sure everybody's current. Refresh your screen if you were getting some buffering issues. Audio is in and out now. So I've got piano going nonstop. Sad music appropriately. 5x5. Thank you very much. I appreciate the reference there too. Okay, so if you're having mixed results on different devices, that would tend to say the problem is not on my end. It would either be in the middle or possibly on your side. Okay. Defendant's going to make a run for it. Apparently, this is his last chance. Did you guys see the other day when he was sitting at the table all by himself, and somebody came in and somebody walked away. I think his lawyer walked away from the table to go talk to somebody, and he pulled out the drawer in front of him. He's like looking around, and he's like slowly pulls out the drawer just to see what's in it. And it's like, what do you think you're going to find? Like a spare handcuff key, or like a file, a sharp spoon? I thought it was funny. The aluminum foil should work great. That will both protect you and act as an antenna. Thanks for the advice, Mr. Upper Torso. Music didn't cut out at all. Okay, this is good. I'm not going to switch. I'm not going to run any speed tests or anything. I still think it's my modem. I think it's a faulty device that can't handle requests from multiple IPs, possibly through a switcher. I think that might be the issue. But I'm wireless now, so I'm not sure why. Okay. Looks like they're all standing, so the jury must be being brought in. Or the judge just walked in, one of the two. But usually they sit down pretty quickly after the judge walks in. So I think jury's on their way. There's usually not anything terribly exciting during the jury instructions. They're pretty standard as far as, from one court case to another. There are some specific instructions that relate to the elements of a charge, for each state, how the laws are written, and depending on which charges are being sought, they'll have some variety there. But usually it's pretty much, you're supposed to weigh the evidence, and you're supposed to, use your information, your judgment on what you saw, and see if the state has proved the charges. Here we got some audio. That's great. So we'll hear what's going on here. I've only got that one song, Lindsay, and I'm not ready to. I'm not ready to play my. I've got some other ones, but they're a little more upbeat. I've got the cat song as well. We can do sound effects. The sound effects don't affect anything. That's like me talking. It doesn't go
All right,
run
go
through
ahead and have a
anything.
seat, everybody.
Play with it.
Good morning, ladies and gentlemen. So on your chairs, you had an additional stack of paperwork this morning. Those are a copy of the jury instructions. So each of you will have a copy of those to follow along with as I read those to you. You'll be able to take those back with you to the jury room. You'll also get the original that's signed and dated by myself, along with the verdict forms. Those will be sent back to you. So just at this point, I'm going to read to you the first 35 instructions. The instructions after that, I'm going to read to you after closing arguments are completed.
I believe he's completely unshackled.
You may notice and wonder why, but at some point, Kathy is going to stop.
It's up to the court
taking
and
notes.
the
There's no
sheriff,
need for her to make a record
bailiffs.
of
The judge
something
might have some
that
instructions
a
as
record
well.
already exists of, so it's redundant. So she'll stop now when I start reading you the jury instructions. Ladies and gentlemen of the jury, the trial information in this case accuses the defendant of the crime of 3 counts of murder in the first degree and charges the defendant, Alexander Jackson, on or about June 15th, 2021, in the county of Lynn, state of Iowa, did, having malice aforethought, willfully, deliberately, and with premeditation, kill Jan Jackson, count 1, Melissa Jackson, count 2, and Sabrina Jackson, count 3, at 4414 Oak Leaf Court Northeast, Cedar Rapids, Lynn County, Iowa. Each of the 3 counts on the trial information include the lesser and included offenses of murder in the second degree and involuntary manslaughter. To these charges, the defendant has entered a plea of not guilty. Upon the issues thus made, you were instructed as follows. Instruction number 1, The trial information is the document that formally charges Alexander Jackson with a crime and is merely the method by which he is brought into court for trial. It is not evidence. Instruction number 2. Alexander Jackson is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of Mr. Jackson. The presumption of innocence remains with Alexander Jackson throughout the trial
He has been
unless the
incarcerated
evidence
the whole time.
establishes guilt beyond a reasonable doubt. Instruction number 3.
Going to turn him down just a little bit. Interesting
Alexander
fact,
Jackson
they're
has
sending
entered
an
a plea of not
unbalanced
guilty.
audio. I mean, like an
The plea of
unlevel.
not guilty is a complete
Right
denial
channel's
of
coming
the
in
charge
hotter than
and
left
places
channel.
the burden on the
If
state
you're
to
using
prove
headphones,
guilt
that's why
beyond
it
a
sounds like he's in
reasonable
your
doubt.
right ear a little bit.
Whenever I instruct you, the state must prove something. It must be by evidence beyond a reasonable doubt. If the state does not prove Alexander Jackson beyond a reasonable doubt, your verdict must be not guilty. Instruction number 4. The burden is on the state to prove defendant guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence or lack of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense and not the mere possibility of innocence. Proof beyond a reasonable doubt does not mean proof beyond all doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of defendant's guilt, then you have no reasonable doubt and you should find defendant guilty. But if, after a full and fair consideration of all the evidence or lack of evidence produced by the state, you are not firmly convinced of defendant's guilt, then you have a reasonable doubt and you should find defendant not guilty. Instruction number 5. If there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. Instruction number 6. You shall base your verdict only upon the evidence and these instructions.
The family are all
Evidence is
laying down right
testimony
now.
in person or by
He pretty
deposition.
much shot them all.
2, exhibits received by the
He's got
court.
family
You
in
may
Oregon,
examine the exhibits
but they're not
closely,
close.
but be careful not to alter or destroy them. 3, stipulations. which
I've never
are
heard that
agreements
before.
between the
Be careful not
attorneys.
to alter or destroy them.
Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes, during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to, which were not offered and received into evidence, are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers. 2, objections and rulings on objections. 3, any testimony I told you to disregard. 4, anything I tell you as part of these instructions is not evidence. And 5, anything you saw or heard about this case outside of the courtroom. Instruction number 7. Certain testimony has been read into evidence from a deposition. A deposition is testimony taken under oath before the trial and preserved in writing. Consider that testimony as if it had been given in court. Instruction number 8. In considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence or circumstantial evidence or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Instruction number 9. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, 1, whether the testimony is reasonable and consistent with other evidence you believe. 2, whether a witness has made inconsistent statements. 3, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. 4, the witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 10. During the course of trial, you've heard testimony from various officers regarding statements allegedly made to them by neighbors and workers in the area where these crimes occurred. These statements were not offered for the truth of the matter asserted. Therefore, you may not consider the statements allegedly made by neighbors or workers as evidence in this trial, and may only use the statements to consider the conduct made by officers in response to the information they received. Instruction number 11. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. Instruction number 12. In this case, Alexander Jackson has decided not to testify. He is not required to testify, and no inference of guilt shall be drawn from that fact. The burden of proof remains upon the state to prove the guilt of Alexander Jackson. Instruction number 13. Evidence has been offered to show that the defendant made statements during 2 video interviews with the police on June 15, 2021. If you find any of the statements were made by the defendant, then you may consider them as part of the evidence. However, the statements and questions of the officers during those interviews are not evidence and may only be considered by you as context for the defendant's answers. You have also heard a recording of the defendant during a 911 call. If you find that those statements were made, you may consider them as part of the evidence. Instruction number 14. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person know the act is against the law, it is necessary that the person was aware he was doing the act and he did it voluntarily, not by mistake or accident. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 15, count 1. The state must prove all of the following elements of the crime of murder in the first degree. On or about the June 15th, there's an extra "the" there, but on or about June 15th, 2021, the defendant shot Jan Jackson with a firearm. 2, Jan Jackson died as a result of being shot. 3, the defendant acted with malice aforethought. 4, the defendant acted willfully, deliberately, premeditatedly, and with the specific intent to kill Jan Jackson. If the state has proved all these numbered elements, the defendant is guilty of murder in the first degree. But if you find the state has failed to prove any one or more of the elements, then you should find the defendant not guilty of murder in the first degree and proceed to determine whether the defendant is guilty of murder in the second degree as defined in instruction number 16.
I can't think of one, Richard.
Instruction number 16, count 1. The state must prove all of the following elements of the crime of murder in the second degree. 1, on or about June 15th, 2021, the defendant shot Jan Jackson. 2, Jan Jackson died as a result of being shot. 3,
He's
the
finding all the
defendant acted
typos
with malice
while he's
aforethought.
reading it to the
If
jury.
the state has proved all of these numbered elements, the defendant is guilty of murder in the second degree. But if you find the state has failed to prove one or more of the elements, then you should find the defendant not guilty of murder in the second degree and proceed to determine whether the defendant is guilty of involuntary manslaughter as defined in instruction number 17. Instruction number 17, count 1. The defendant must prove all of the following elements of involuntary manslaughter. On or about June 15th, 2021, defendant recklessly utilized a firearm. 2, the defendant did the act in a manner likely to cause death or serious injury. 3, by doing the act, the defendant unintentionally caused the death of Jan Jackson. If the state has proved all of the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter, and you should find the defendant not guilty as to count 1. Instruction number 18, count 2. The state must prove all the following elements of the crime of murder in the first degree.
We'll see. They might
On
have
or
the
about
accidental,
June
or
15th,
not accidental, but the
2021, the defendant shot Melissa Jackson with a
negligent one in there.
firearm. 2, Melissa Jackson died as a result of being shot. 3, the defendant acted with malice aforethought. 4, the defendant acted willfully, deliberately, premeditatedly, and with the specific intent to kill Melissa Jackson. If the state has proved all these numbered elements, the defendant is guilty of murder in the first degree. But if you find the defendant has failed to prove any one or more of the elements, then you shall find the defendant not guilty of murder in the first degree and proceed to determine whether the defendant is guilty of murder in the second degree as defined in instruction number 19. Instruction number 19, count 2, the state must prove all of the following elements of the crime of murder in the second degree. 1,
Yes,
on
jury
or about
instructions,
June
35
15th,
instructions.
2021, the defendant shot Melissa Jackson. 2, Melissa Jackson died as a result of being shot. 3, the defendant acted with malice aforethought. If the state has proved all of these numbered elements, the
We still
defendant is
have
guilty
closing
of murder in the
arguments after
second
this,
degree,
and then
but
charge
if you
the
find
jury,
state has
then
failed to prove any
deliberations.
one or more of the elements, then you shall find the defendant not guilty of murder in the second degree and proceed to determine whether the defendant is guilty of involuntary manslaughter as defined in instruction number 20.
I don't
Instruction number
recognize you.
20,
You're going to have to
count
tell me what
2.
your name was. I
The
don't
state
remember.
must prove all of the following elements of involuntary manslaughter. On or about,
Found another
I'm
mistake.
just crossing out those extra thes on mine and initialing them. So on the original, it'll be correct. On or about June 15th, 2021, defendant recklessly utilized a firearm. 2, the defendant did the act in a manner likely to cause death or serious injury. 3, by doing the act, the defendant unintentionally caused the death of Melissa Jackson.
We'll see you, T-Rocks.
If the state has proved all of the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter, and you shall find the defendant not guilty as to count 2. Instruction number 21, count 3. The state must prove all of the following elements of the crime of murder in the first degree. On or about June 15th, 2021, the defendant shot Sabrina Jackson with a firearm. 2, Sabrina Jackson died as a result of being shot. 3, the defendant acted with malice aforethought. 4, the defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Sabrina Jackson. If the state has proved all of these numbered elements, the defendant is guilty of murder in the first degree. But if you find the state has failed to prove one or more of the elements, then you shall find the defendant not guilty of murder in the first degree and proceed to determine whether the defendant is guilty of murder in the second degree, as defined in instruction number 22. Instruction number 22. The state must prove all of the following elements of the crime of murder in the second degree. On or about June 15th, 2021,
Wilmus, let me check.
the defendant shot
It's gonna get
Sabrina
ugly for just a
Jackson.
second.
2, Sabrina Jackson died as a result of being shot. 3, the defendant acted with malice aforethought. If the state has proved all of these numbered elements, the defendant is guilty of murder in the second degree. But if you find the state has failed to prove one or more of the elements, then you shall find the defendant not guilty of murder in the second degree and proceed to determine whether the defendant is guilty of involuntary manslaughter as defined in instruction number 23. Instruction number 23.
Would you
The state must
kindly?
prove all of the following elements of involuntary manslaughter.
It should work.
On or about June 15th, 2021, defendant recklessly utilized a firearm. 2, the defendant did the act in a manner likely to cause death or serious injury. 3, by doing the act, the defendant unintentionally caused the death of Sabrina Jackson. If the state has proved all of the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter, and you shall find the defendant not guilty as to count 3. Instruction number 24, murder in the second degree at instructions 16, 19, and 22 does not require the specific intent to kill another person. Instruction number 25, as used in instruction numbers
Sunshine and
15,
Sunflowers,
18, and 21,
If you go to my,
willful means intentional
link
or by
tree.
fixed design or purpose and not accidental.
let me tell you in the
Deliberately
break.
means
I'll tell you in the
after
break
having
because that work.
deliberated,
Because it's a
which
little
is
bit
to
long
weigh in
explanation.
one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Deliberation and premeditation need not exist for any particular length of time before the act. Instruction number 26. Malice, as used in instructions 15 and 16, 18 and 19, and 21 and 22, is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed design, which means a fixed purpose or design to do some physical harm to another, which exists before the act is committed. It does not have to exist for any particular length of time. Instruction number 27. Malice aforethought may be inferred from the use of a dangerous weapon. Instruction number 28. Serious injury, as used in instructions 17, 20, and 23, is a condition which cripples, incapacitates, weakens, or destroys a person's normal mental functions and/or a bodily injury, which creates a substantial risk of death or which causes serious permanent disfigurement or extended loss or impairment of the function of any bodily part or organ. Serious injury includes, but is not limited to, skull fractures and rib fractures. Substantial risk of death, as used in instructions
Hey, Sunshine, I
17,
just posted the
20,
link
and
to it.
23,
This is the
means
switcher
more
I
than
use.
just any risk of death, but does
It's a
not
spendy
mean
one,
that
but I want
death
to
is
talk to you
likely.
before you buy
If
one.
there is a
'cause
real
you
hazard or
might be
danger
able
of
to use
death,
one that's cheaper.
substantial risk of death is established. Instruction number 29, a person is reckless or acts recklessly, as used in instructions 17, 20, and 23, when he or she willfully disregards the safety of persons or property. It is more than a lack of reasonable care which may cause unintentional injury. Recklessness is conduct which is consciously done with a willful disregard of the consequences. For recklessness to exist, the act must be highly dangerous. In addition, the danger must be so obvious that the actor knows or should reasonably foresee that harm will, more likely than not, result from the act. Though recklessness is willful, it is not intentional in the sense that harm is intended to result. Instruction number 30, a dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used in its designed manner, is capable of inflicting death. It is also any sort of instrument or device actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting
Yes,
death.
they are.
You are instructed that
I
a
microwave
firearm,
mine.
such as a .22 rifle, is by law a dangerous weapon. Instruction number 31, if a person has the opportunity to deliberate and uses a dangerous weapon against another, resulting in death, you may, but are not required to infer that the weapon was used with malice, premeditation, and specific intent to kill. Instruction number 32, specific intent means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 33, you must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. You must consider all the instructions together. No one instruction includes all of the applicable law. As you consider the evidence, do not be influenced by any personal sympathy, bias, prejudices, or emotions. It is common to have hidden or implicit thoughts that help us form our opinions. You are making very important decisions in this case.
Good
You
morning.
must evaluate the evidence carefully. You must avoid decisions based on things such as generalizations, gut feelings, prejudices, fears, sympathies, stereotypes, or inward or outward biases. The law demands that you return a just verdict based solely on the evidence, your reason, and common sense, and these instructions. As jurors, your sole duty is to find the truth and do justice. Instruction number 34, nothing I have said or done during the trial was
We're almost
intended
done.
to give any opinion
One
as
more
to facts,
instruction.
proof, or what your verdict should be. Instruction number 35, the duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment.
Okay, here we go. Opening or closing statements.
All right,
Prosecution
ladies
first.
and gentlemen, I'm going to read the remaining instructions once we're done with closing
yeah, good,
arguments.
good.
So at this time, counsel for the state and counsel for Mr. Jackson will have an opportunity to present to you and make closing arguments. I believe Ms. Slaughter on behalf of the state will go first. Then Mr. Johnson will have an opportunity to make his closing argument. The state will also have then a chance to make a rebuttal closing argument after Mr. Johnson is done. During the closing arguments, I expect that the attorneys will be in part summarizing the testimony that you have heard and the evidence which has been presented. In doing so, they're going to be recalling that evidence and testimony as you will be later doing. Neither one of them will be intentionally trying to mislead you, and if their recollection of testimony or evidence is not the same as yours, you should rely on your own recollection or testimony if you believe that's the accurate
Is that
version.
screen to his left crooked?
The arguments that counsel are making and their summaries are merely that. Again, they are not evidence, and should not be construed by you as evidence. I anticipate that one or both of them may also talk to you about the instructions and the law. Again, what they tell you is not the law. The law that you are to apply is what I've given you in the instructions and will give you in the final
Well,
instructions.
Samantha, tag is fantastic. I realize some of you guys go to other channels. I'm not
summaries
hurt
are
or
intended to help
offended at
you
all.
in understanding their respective positions.
Just when you come
and
back,
you
bring
should
friends.
give them both your careful attention. And with that, Ms. Slaughter, are you
Seriously, it's
ready
crooked.
to make your argument for the state? You may.
Now I can't look at anything but that.
Ms. Slaughter, do you need the
Are you gonna do PowerPoint?
no
Please no.
no laptop? Okay. All right. You could tell by my gesturing. All right.
You're gonna have to turn the mic on, ma'am. Red light's off. Red light's off. Push the button. Thank you. No bun today. I guess the focus
June
group
15th,
was not
2021.
impressed.
Alexander Jackson makes a call to 911. In that call, immediately after the phone is picked up by the dispatcher, he says, "Someone broke into our house. Our address is 4414 Oakleaf Court Northeast. I've been shot. My other family member's been shot. I need help immediately." That phone call
Just
started
kidding.
a chain of events.
This is the power one. This is where they're attacking
Ladies and
him.
gentlemen, after the last several days, you sat in this courtroom and you heard testimony from several witnesses about the events that unfolded the morning of June 15th, 2021. What you heard was that during that phone call, dispatch got on the phone, got on the radio, and immediately sent officers in the direction of the Jackson household. And the officers arrived. With limited information that was provided through the 911 call, they took up location and parked their
Yeah, they should
vehicles
get equal
up the
time.
street for safety purposes. They had brief conversation. They discussed their strategy for approaching this house. And with the information that they had initially received from dispatch, immediately felt like something was off. Something's not right.
Yeah, we're gonna save it
You
for
heard
part 2.
two officers through their body camera microphones suggest that maybe this was even a swatting call, that someone had made a prank call and attempted to get emergency personnel to respond to this house. It didn't sound right. The officers are seen and heard on their body cameras relaying information and receiving information from dispatch. Who's all in the house? Can you get somebody to come out? See if you can get the mom or the sister to come outside. Simultaneously to those communications occurring with dispatch, Alexander Jackson is still on the phone. He says that he's been shot in the foot, that someone broke in, he's been shot, his dad's been shot, he was shot in his left foot. When asked by the dispatch operator who shot him, who broke in, his response was a man. When asked how this man got into the house, Alexander Jackson's response was, "I think they came in the back door, but I'm not an expert." When asked who he was home with, the defendant said that he was home with his sister. She was in her bedroom. But never in that 911 call do you hear the defendant yell out to his sister, "Sabrina, I've been shot. Dad's been shot. Are you okay?" Nothing.
She's doing a good job of this.
And the reason the defendant isn't calling out to his sister is because he knows that she's dead. He doesn't call out to his mom. Mom, I've been shot. Mom, are you okay? Mom, help me. Check on dad. Because he knows his mother is also dead. When the 911 dispatcher attempts to get more information, the defendant says he's black, and the dispatcher asks his shirt
I
or
just
his
came
skin.
inside. He didn't really say his path.
Both. So now we have a man with a black shirt who's black. And that's all we've got.
That's
Do
a
you
good
know
one,
if your
Shutterbug.
mom and sister are safe? Well, I don't see them. They should be safe. Remember, ladies and gentlemen, that when officers finally felt that they could make a safe approach to this house after Officer Brown perched up in the trees because the door was open and there were several windows, and the other officers made the decision that the door was open so that they needed to enter.
Charlie, I missed the first 2 days. So I want to hear
Remember
this, and then I
where
want to reserve judgment until after
Alexander
they're done with
Jackson
this,
was
because I missed
sitting
a couple days of
when
testimony.
those officers came in? You can see it perfectly on Officer Brown's body camera right about 7 minutes and 55 seconds. The defendant is literally sitting outside of his sister's bedroom. The only thing that separates her room and his room is that small wall, and he's sitting right there holding his foot. But he doesn't know if his sister is safe. Throughout the call, the dispatcher goes on to ask Alexander if there's any guns, any weapons left. And Alexander Jackson tells the dispatcher, well, there is a gun on the floor. Did this intruder leave it behind? No, it's our gun, but we got shot with it. And you can hear the inflection in the dispatcher's voice, because even she's caught off guard, and she says something along the lines of, you got shot with your own gun? Yeah? Question mark. Officers come in, and immediately upon entering that back door, they see Jan Jackson laying face down in a pool of his blood in that downstairs lower level living room. And not knowing if the person on the floor initially is the caller, or you hear Officer Buckles through his body cam asking the person on the floor to show him his hands. But Jan Jackson could not show his hands because Jan Jackson was dead. And you see officers come in. They come in and they start to do a protective sweep. They're checking back rooms, they're checking storage rooms, anywhere big enough for a person to be. Officer Kaczynski goes down that hallway past the defendant and checks the sister's room. And you hear him yell out, we've got another one. We've got another victim down here, another dead body. And that dead body was Sabrina Jackson, laying in her bed under the covers with what officers believed was only one gunshot wound to her left eye. The remaining rooms downstairs were checked as officers made their way up to the main level of this home and continued their protective sweep, checking the garage, checking the kitchen, checking all of the rooms, the closet, before they made their way around the back of that stairway into the master bedroom, where they found Melissa Jackson's body, also deceased, laying on the floor. Pile of blood on the bed, and then blood on her person and her final resting spot. Based on the information that was being received from Alexander Jackson, K-9 Officer Buckles made the decision that he was going to check the area track the area to see if they could catch the scent of this alleged intruder. And you see it. The dog goes out, makes a stop in the same area where the vegetation is disturbed, where Officer Brown was crouched down by the trees, follows through the trail, sniffing and tracking, and picks up another scent along that path along the back of the house where officers had come around the backside of the house. Officer Brown gets in the ambulance and rides to the hospital with the defendant, and you can hear and make the determinations and judgments based on what you heard in that video of the statements that Alexander Jackson made to the EMT on his route to the hospital. Investigator Bosenberg first goes to the hospital, photographs the defendant, takes pictures of the injury to his foot, takes some swabs, and then he returns to the house. And he returns to the house to process the scene. And you heard from Investigator Bosenberg that there are certain methodologies and protocols used when any crime scene is being processed, and that there are some variations to those protocols depending on the size of the crime scenes and how long it can be held. You know, there's a difference between a crime scene in the middle of a road that needs to be opened back up and a house that you can secure and hold for 4 days. But essentially, what Investigator Bosenberg testified to is that over a 4-day period, he and his partner processed the residence at 4414 Oakleaf Court Northeast. And ladies and gentlemen, during the processing of that evidence, what you saw is that behind the couch, just inside of that lower level living room, just inside of the door, was a pile of shell casings. And throughout the investigation, you came to learn some things about the murder weapon in this case and the specific ways in which it ejects spent shell casings out of the bottom in a group, opposed to ejecting out of the top and throwing them. A pretty tightly grouped pile of shell casings laid right behind that couch. You also saw photographs of Investigator Bosenberg as he progressed his way down the stairs. And it was very obvious from the evidence that as Jan Jackson left his office the morning of June 15th, leaving behind his cup of coffee and his half-eaten muffin to come downstairs, that the defendant was perched up behind that couch and started shooting his father. One shot to the neck area, one shot to the right chest, one shot to the left temple. You saw one shot, which was evidence tent 17, was a missed bullet hole. You saw minimal blood spatter at the bottom of the stairs. And then Jan Jackson fell. He fell face first into the carpet right at the base of those stairs. And then the defendant, for good measure, stood over him and put 2 more bullets in the back of his head. Five shots in total for Jan Jackson. 1 missed shot into the wall. 6 bullets. We found out during autopsy from Dr. Kelly Cruz that Sabrina Jackson had more than the original believed bullet shot just to her eye, that there was additional wounds that were discovered under the blanket. The initial shell casing that was found in Sabrina Jackson's room was right by the door. In order for that bullet to travel the path that it took into her left rib, out of her right-ish abdomen area and into the arm. She had been laying in a position that was visible and exposed to the defendant when he shot her from that doorway. Dr. Cruz testified that though that shot could have killed her, it's very possible that she would have been able to roll over after that initial shot. And that's the exact position that her body was found in, ladies and gentlemen. After being shot through the rib and out of the abdomen and back into the arm, she rolled over into a fetal position. And the defendant got closer and shot her in the eye. I say got closer because the second shell casing was not found during the initial search. And Investigator Bosenberg explained that when they process a scene, they go through and they find the very apparent and obvious evidence and they mark it. And then they start to peel back like an onion, I think he described it, the layers of the crime scene, finding additional evidence. So after enough was done with the bodies that they were confirmed to be deceased and put into their
This is the
body
prosecutor,
bags, which
yes.
were then locked and transported to the medical examiner's office, another shell casing fell out of that bedding. And it was seen next to that or behind that teddy bear. 2 shots, 2 shell casings found in that room. That's 8. What you saw next is that Melissa Jackson's bedroom, or the master bedroom that she and Jan Jackson shared, was processed. And what you saw in those processing photos is that right when you walk in the bedroom door, again, there was a very neat cluster or grouping of spent shell casings right inside of that doorway, indicating that several shots were fired from that specific location. And you saw those rods, those wooden dowels that were used and placed in the headboard to give some idea of the trajectory, and those pointed right back at that doorway. What we saw in that master bedroom is that 3 shots were fired at Melissa Jackson as she laid in that bed. One of them grazed her scalp, likely the injury that caused the blood found on the bed. And then she rolled out of the bed. One more shot from a distance to her temple, her right temple. And then a final shot, point blank, into her left eye. And you saw evidence in that case, or in that shooting, of that very close, that stippling, as Dr. Cruz referred to it, and as that soot and that burn powder that had burned into her skin, causing that discoloration. Inches away from his mother when he shot her in the face. On top of the soot and the stippling that were seen in the injury, there was that extra shell casing that didn't quite fit in the group, found right in between Melissa Jackson's legs, that would have shot down with a slightly forward angle as it was discharged from that .22 caliber Browning. The defendant wanted to make sure that each one of his family members was dead. Now, during the interview with the defendant, he told investigators where he was at when all of this was happening. The 5 shots that were fired off in the master bedroom, the 6 shots with Jan Jackson, the 2 in Sabrina Jackson's bedroom, and the defendant, he was outside, sleeping on a screened-in porch in a sleeping bag with his dog when all of this happened. And though Investigator Bosenberg testified that a .22 caliber is one of the smallest weapons on the market. I think he said there was a 17 caliber that's not used or isn't customary, but the .22 is small caliber weapon. That even though it's small, and it isn't as powerful, doesn't shoot as loud, you would think that gunshots, especially that many, would wake the defendant. And he testified that he did get woken up by them. That he got woken up by gunshots, he heard approximately 10, and that he ran downstairs and saw this now tall man in all black, who is a black man, messing with a gun standing over his father. Alexander Jackson says, I ran at him, pushed him. I tried to take the gun. Then, well, you see what happened. Investigator Denlinger and Investigator Lucina tried to tie the defendant down to some more detail, and the defendant remained very vague with the information that he was willing to offer. And I submit to you, ladies and gentlemen, that the vagueness in the defendant's story was intentional, and you'll see that as the interview progressed, that vagueness, those open holes that were left in his original story, he was slowly able to fill with additional detail as those additional pieces of information helped him tell his story. You hear that this black man wearing black, who was tall, then had on green shoes. Then you hear that this black man who was tall, wearing black clothes and green shoes, now has on a black ski mask. And then approximately 12:55 in the afternoon, as officers are talking to the defendant about how the gun got into the living room in the first place, the defendant conveniently puts gloves on the intruder. Investigator Bosenberg testified, ladies and gentlemen, that before he ever moved the firearm, that he did some processing of that weapon right there on the scene. That he took some initial swabs, and he explained how the buccal swabs are 2 in a package, and you swab and then you put them back, and how that evidence was collected. But he testified that there were some specific locations on the firearm that he wanted to test before moving it, potentially contaminating it, to make sure that he preserved the potential for DNA to be found on that firearm. Now, ladies and gentlemen, the defense is going to stand up here and they're going to tell you that the state failed or the investigators failed to test all of the swabs that came off of that gun. But I submit to you that the additional swabs that were taken were done in a speculative nature, where the original swabs that were taken at the scene by Investigator Bosenberg were taken of parts of this firearm that were guaranteed to have been touched. Guaranteed to have touched that trigger at least 15 times. And this isn't just a brush of the trigger, pulled that trigger at least 15 times. Swabbed the location where the bullets are loaded into the gun. Had to have happened. The defendant, during his interview with investigators, says that he unloaded. First, he's not sure where the gun was stored before the gun got into the living room, where he and his father, the night before this, decided that out of the blue they were going to clean this weapon because the last time they had used it, some umpteenth time ago, that this gun jammed. So he's not sure where the gun came from. But the gun gets brought into the living room, and when he's asked if it was loaded. He mentions that he was putting the bullets back in the box, that he was unloading this weapon. And when Investigator Lucina pressed on, is there going to be anybody else's fingerprints on these bullets? No, I don't think so. There shouldn't be. The intruder had gloves. She said, well, you didn't say he had gloves before. And the defendant says something along the lines of, well, I didn't say whether he did or didn't have gloves, did I? He knows there's not going to be anybody else's fingerprints on the bullets because he is the one who unloaded the gun. He is the one who reloaded the gun. He is the one who reloaded it again.
It was a Browning, wasn't it? Yeah. Browning 22. Thanks, that guy.
The DNA swabs taken from that firearm were processed by the DCI lab. Not only did they not return any DNA profiles for an unknown person, unknown intruder, they didn't return profiles for the defendant either.
Hey, Charlie, I've been sort of watching this case. If you got a question, let me know. I'll try to answer it.
Touch DNA that we heard about. Investigator Denlinger testified that in all of his years of history and doing investigations, that he doesn't get touch DNA. And Mr. Johnston brought up another case in which he claims that the DNA was from touch DNA because it didn't come from a wet spot or a stain. That doesn't make it touch DNA. No DNA from this gun. And the investigators, based on the lack of DNA from the specific 5 places that were guaranteed to have been touched, made the decision not to send the other swabs in. Over and over, the defendant was asked questions
No, you're good.
about
Charlie,
what happened
I
that
love
morning.
that you disagree with me almost all the
Where
time.
were you shot?
Because you give me a pause to
Downstairs.
stop and think about things a little different direction. So
Never really says where
appreciate the
he
perspective
was
you
shot.
bring.
Says that he
Just
tried to take the
Sometimes you have an
gun
edge to you. So,
from this
just be
supposed
gentle,
intruder.
but please keep sharing your opinions.
And that either he shot himself in the struggle or this supposed intruder shot him in the foot. Within 30 seconds of being shot, he claimed that he called 911 and that he had to go into his bedroom to get the phone, to make the phone call. The defendant, through his statements during that interview, wanted the police to believe and want you as jurors to believe that on this night and into the morning, this hot night that's causing Corsa to pant, where it's too dangerous for this canine dog to do her job, that the defendant at 320 pounds is outside sleeping in the heat in a sleeping bag with his dog with no phone, because his phone's downstairs in his bedroom. And that's where he had to crawl to get the phone to call 911. Except investigator Denlinger testified that there was activity on the defendant's phone during the 6 a.m. hour. Clear up to, I believe, 6:57 or 6:53, check your notes, where he's Googling things and he's on this social media app called iFunny, and that there's all this activity on the phone. And we're supposed to believe that somewhere between him playing on his phone, he gets his phone into his bedroom from the porch, makes his way back up to the porch and lays down and goes back into a sleep so sound that he doesn't hear his family being executed.
Sorry, Kara. I had some background noise going. I'm trying to monitor 2 things at once. I'll mute
You
that.
heard Investigator Bosenberg, ladies and gentlemen, talk about the part of his job where he test fires weapons. That when firearms are recovered, he's responsible for test firing those firearms. And that in a year's period, he does 80 plus guns. And that in his career, he's fired hundreds of different weapons. And you heard him testify that as part of the processing of this .22 caliber Browning, he wanted to test fire it as well. And in order to do that, he had to load the firearm. And what he found when he attempted to load that firearm is that this specific Browning rifle was so unique to him, trained and experienced, that he had to watch a YouTube video on how to load this gun. And you saw portions of that YouTube video that Investigator Bosenberg watched. This isn't typical as far as how this gun is loaded. You saw that in the buttstock of that gun, there was my words, something you got to twist, and then you got to pull out this pole, and then there's a hole in the side of the gun where you've got to pump a bunch of bullets, and then you've got to work this stick pull thing back into the gun and turn it. And that was done twice by this intruder. Once to load the gun.
This
because
is his first
Alexander
trial.
Jackson said that it was unloaded when he left it at the
Thanks, Loomis.
fireplace. And then
Katrina.
again, after he ran out of those 11 bullets. And there was some conversation about the processing of those bullets and the shell casings and their firing pin impressions and them being ran through the NIBIN system. And somewhere when this person from ATF, I think somebody who was contracted through the ATF, I think Investigator Bosenberg said, when she hit the drop down to pick the .22 caliber rifle, she selected short. But he told you that the shell casings from the scene of the crime were longs. And the long and the short makes a difference, right? Because of how many bullets can be loaded into this gun at a time. And we took a recess, and he told you that during that recess, he conducted an experiment with the actual bullets found at the scene, the .22 caliber long bullets found at the scene, and that during that experiment, he could not load more than 11 bullets into this gun. And he testified about the size of the long being around 16 millimeters, which is significantly longer than the shorts, which is around 10 millimeters. That gun on June 15th was loaded with longs. The longs are what was found. The shell casings that were found were longs. There was an error in that report from the drop down. 11 shots, over 15 fired, 3 left in the chamber. That gun had to be reloaded, ladies and gentlemen, by this intruder. Investigator Denlinger talked to you about gunshot residue. Gunshot residue being kind of a damned if you do, damned if you don't test for it situation. And he explained that the state lab in Iowa, which does criminal analysis for the entire state, stopped testing
Poor choice
GSR in
of
the
words
90s.
there.
And he gave lots of reasons for that, agricultural, and that gunshot residue has too many false positives or even false negatives. And he explained that gunshot residue, I think he gave the example, if a gun is fired in a car, everybody in the car is going to have gunshot residue. If someone is wrestling an intruder covered in gunshot residue, that gunshot residue is going to transfer. If a person cleans their firearm having not cleaned it since the last time he and his father went to the range to shoot it, and then doesn't change his clothes because you see the outfit he's in the night before these 3 murders and the same outfit the morning of the same murders, that would leave gunshot residue on his hand. The defendant fighting and struggling over a gun that goes off, that's already been fired multiple times, is going to leave gunshot residue on his hands. So gunshot residue is not going to prove or disprove any theory of this crime, other than it's going to exist where the gun has been fired that many times. If there was a struggle, it's going to be on him. If he's the shooter, it's going to be on him. State lab doesn't test for it anymore. Investigator Bosenberg testified that after having collected the gun and how it's wrapped and packaged and taken back to his lab, how it's unpackaged and how it's processed and how the firearm is super glue fumed. And he explained that there's this chamber that the firearm is put in, and then the fumes from the super glue attached to the oils or residue, whatever it is from our bodies that create fingerprints when we touch surfaces, and that he was able to get, for lack of a better word, 3 prints on this gun, and that he labeled those prints Leighton 1, Leighton 2, Leighton 3. He described Leighton 1 as the left palm print, and it was found from the left side, the left buttstock of this firearm. And that the quality of this print was good quality, not smudged, not drug, good quality print, where there were several identifying factors, and then he ran that through the system, and the system produced 5 names that this potentially could belong, 5 numbers, identifying numbers, that this print, known Leighton print, could have possibly belonged to these 5 producers of prints, and that he compared them. And that in comparing them and comparing those identifying markers, he found identifying markers on the print from the gun to the first number that was produced by the system, and that number happened to match up to Alexander Jackson. And that then he took a confirmatory print, what he referred to as a known print, from the defendant.
Hey, Lindsay, they
And he
say they don't
compared
test for
Leighton
gunshot
1
residue
to
anymore.
the left palm of the defendant and matched. He concluded that the palm print on the buttstock of the left side of that gun was the defendant's. And then he went through the same process, because on the right side of the gun, just a little bit before and ahead of the left print, he found a second latent, and he matched that to the identifying number that the system produced, and then took that and used the known print from the defendant that was collected and confirmed that the print on the right side of that buttstock, also good in quality, not smudged, not smeared, was the defendant's. Then he talked about a third latent print, that there are certain identifying markers that are significantly easier or more reliable to match to prints, specifically where the
It's the lady that had the beehive
markings
hairdo
left
earlier
from
in the
prints
trial.
come to curves or points, and that this Leighton 3 had mostly horizontal lines, and that he was unable to match or confirm that the horizontal lines or the Leighton from number 3 matched any of the 5 prints identified from the system. And he told us that that third latent was only about 1 centimeter big, that he couldn't find where those just striped lines or horizontal lines matched up to those 5 prints or the defendant's, but he couldn't exclude it, just that it was poor quality, that it wasn't enough, that the identifying factors that he was hoping to see and look for didn't exist, and so he can't say it was or was not the defendant's. But Leighton 1 and Leighton 2 were good quality prints, big prints, palm prints on the butt of that gun, in a place that would be atypical of a regular shot, but consistent with where the gun would be held when the defendant shot himself in the foot with it. Ladies and gentlemen, Investigator Bosenberg testified that in this house, there was not a lot of blood spatter. I think I spent that whole day calling it splatter and was corrected. It's spatter. There was some at the
Finally.
bottom of the stairs, on the wall where Jan Jackson was shot repeatedly. I believe Investigator Bosenberg testified that there was minimal spatter around Jan Jackson's head imprint where his final resting place was on the carpet, that there was minimal spatter found in the hallway where the defendant walked with his bloody foot along that floorboard area. And then blood spatter in the defendant's bedroom. In the defendant's bedroom, at the foot of his bed, next to that leg. And I submit to you, ladies and gentlemen, that the spatter was found in the bedroom next to the bed because that's where the defendant stood when he shot himself in the foot. He described shooting himself in the foot as a fountain-like effect, that it was bleeding out of the top of his foot. That spatter left behind indicates just that, proves just that. The defendant attempted to tie off his injury with a belt tourniquet where he pulled that belt so high that the clasp of the belt popped off, and you see the belt over here and the clasp over here, right at that dark pile of blood where the defendant stood and shot himself. What else is important about the evidence in that bedroom is that when asked about making the 911 call, the defendant talks about how he made it just moments, seconds, 30 seconds after he got shot in the leg, and that he ran into his room to get the phone. But when you look at those footprints, those bloody footprints, they don't enter the defendant's room. They exit. They exit the room because that is the room where he shot himself. Not out in the downstairs living room where this supposed struggle with this alleged intruder took place. The spatter and the footprints prove to you, ladies and gentlemen, that the defendant was in his bedroom when he shot himself in the foot. Approximately 9 a.m. and 50 seconds in that interview video, the defendant said he thought it'd hurt worse getting shot in the foot. He thought it would hurt worse. That's not something that's contemplated. You don't wake up and, gosh, I wonder what it would feel like to get shot in the foot by my own .22 Browning rifle. You think about what it's going to feel like to get shot in the foot when you've planned to try and cover up 3 murders that you've committed by shooting yourself in the foot, ladies and gentlemen.
I don't think they ever found the bullet that went through his foot.
I thought it hurt worse.
I want to see those footprint evidence again because
The defendant
I'm
thinks
not
he
sure if the
spooked him.
state's story lines up with what I
I
see.
think I spooked him or something. Ladies and gentlemen, a common and reoccurring theme that you're going to find as you go back over your jury instructions is that in multiple places in those instructions, multiple different instructions, it says that you as jurors are to use your reason and your common sense. It does more than say it. It demands that you as jurors, when you go through this evidence and evaluate it and give weight to it, that you use your reason and common sense. And I submit to you, ladies and gentlemen, that as you process that evidence and as I sit down and Mr. Johnston stands up and then I get to talk to you one more time, that as you're evaluating everything that you've seen over the last couple of weeks that's been presented in this case using your reason and common sense, you're going to find that the defendant's story does not make sense, that it is unreasonable to believe the story told by the defendant. And I'm asking you now, and I'm going to ask you again when I stand back up, that when you go back and you deliberate over this case and you process the evidence in this case, that you as jurors return verdicts, murder in the first degree, for the murder of Jan Jackson, the murder of Melissa Jackson, and the murder of Sabrina Jackson. Thank you.
Okay, so that was
All right.
relatively
Ladies
quick.
and gentlemen, we're going to take a recess now. I think it's a good, before we start with the closing argument on behalf of the defendant.
Sorry, I'm
good
not
time
trying to
take
mess with things.
15
I
to,
accidentally clicked the mug
approximately
link.
15-minute recess. So again, I'd remind you of the admonition that I've given you previously, still in effect, and ask that you be ready to go in approximately 15 minutes.
Here's what I'll say. I'm super excited to see. First of all, we're going to hear the defense go. Maybe have some music there. We'll see how it goes. Depends how drama filled their close is. But I'm really excited to see prosecution again, because a lot of times what you get on the first part of the prosecution closing is different than what you get on the second part. Because the first time they have to be careful, whatever. The second part, they can just hammer it in, and a lot of times you get a lot more emotion, a lot more power. And the first one was really well delivered. She did a great job telling the story from detail. It looked like to me, like some of you mentioned, that she didn't appear to be reading from notes. This was all from memory, and it was very logical, and just assembled the facts clearly and put it together in a way that the jury might be able to say, yeah, I understand what she's saying. I agree to that same idea. Let's see, is that there we go. Not showing any kind of remorse or to Mrs. family. Yeah, that to me, Abby, is strange, but it's not guilt, right? I can't judge how someone else shows remorse. I mean, I had a good friend who passed away, and the family showed remorse differently than I did. Even in mourning, even at the funeral, the family showed remorse differently than I did. And so I can't judge him for that fact, judge him for that. It does seem strange, and it's just one more piece of evidence. I guess the jury can weigh everything, but he hasn't testified, so I'm not sure how much weight they should put on his reactions in court to what's been going on, or what his reactions while he was being treated or on 911. That was an excellent state closing. Yes. Has anyone ever heard of the Jackson family? That Jackson family wasn't a train wreck. Yeah, I know a couple that are good. Shutterbug says, well, as a Jackson, I can confirm it runs with the family name, apparently. So Shutterbug. Okay. There's usually a different attorney the second time. Yes, and she said she's going to stand up and do round 2, which will be awesome. Let's see. I have no doubt, but I have common sense. I'm super excited for the finish. I think we know what the defense will say. I don't think they have any smoking gun they can pull out here. They didn't have one during the testimony, but they're going to hit on the fact that there's a lot of circumstantial evidence here, and that the little bits of hard evidence that they have fit very well with the defense's story. So, is the moonwalk coming in? I missed the moonwalk. What was the moonwalk? Sharon, she said she would be doing the final closing, which, I mean, there's nothing against that. They get to decide who does what. The judge just wants to know who's speaking. You know, you don't have to switch. It's not like in tennis where, you know, one guy serves, the next guy has to hit next, and, you know, don't alternate back and forth. It's not, I assume that's how tennis goes. I'm not a big tennis player myself, but judge made you thirsty. That's time to drink, right? Can't judge either. I'm a giant crybaby. Yeah, sadly, I don't think I'm going to do any polls. I'm not going to do anything that will break the internet. As long as we're up, we're going to keep it up and running. So I'll do just modest streams and a little bit of transitions. We don't do any of the fancy 3-box stuff that we were doing before. I'm going to keep it simple here until I can get this. I need to find out where the weak link is. And I mean, if it's just an internet switch that needs to be replaced, that would be awesome. I mean, that's, you know, I'd buy one this afternoon. We'd be fine. They're relatively cheap. When she said she didn't cry out to his mom and sister when he saw that his dad, made me really think he's definitely guilty. Right, 7. That would be my response if I was in a house with family members who, you know, I love, who we hang out with all the time. I'm aware we live together, type thing, and something happened, especially with a surprise intruder. I'd be like, "Hey, get the gun," or something. You know, you'd want to shout something out to alert them, especially if you didn't know what the situation was. But there was no evidence of that, which doesn't look good for him. But once again, it's not evidence that he did it. It's just more evidence that things aren't adding up. Literally, yes. You've got literal and figurative, and in this case, it was literal. I have a hard time with that word. I sort of swallow it. Denise says, this is true, RA, about the emotion. I cry at everything, so I show my emotions, but not everyone does. Yeah, some people, they grieve internally, and they, you know, there was, like I told you, the friend that passed away, to them, they said she would want us to move on and be strong and not cry. And I'm like a mess of tears, you know, and you can barely talk through sobbing, and they're not like happy and joyful, not like a Mark Jensen type response, but at the same time, they're all composed and together, and for them, that was how they felt it should be, and they were able to do that. I mean, nothing from him, says Tom. Even when they went through pics of his dead family, he went into great detail, but no reactions. A little fishy. Yeah, it doesn't add up. It's just one more piece. I'm never able to hear the metaphor without thinking of Jackson. If common sense is anything like a gut feeling, you shouldn't rely on that in a criminal case, right? They're supposed to weigh the evidence, Charlie. The jury really is supposed to weigh the evidence and then make their own conclusion that way. And it's a tough job as a jury. You know, very rarely do you walk into a case and you have all the evidence scientifically proven with, you know, multiple tests that are absolutely conclusive, and there's no other option. There's at some point, though, they have to say, you know, I believe this guy and I don't believe that guy, or she sounded very credible and this person didn't. The way people grieves is varying from histrionics to deafening silence. Oh, I think it's like hysteria. Is that the same type of word, Michelle? It's a new word for me today. To deafening silence, from wanting audiences to isolation, as many ways as one can connect. Same with remorse, I suppose. Yeah. Let's see. Jackson, it's now Shutterbug's maiden name. So you've got a new last name, so you're separated from the crazy by one step. Parents died 9 months apart. I'm sorry. I grieve different for both. Sunshine Sunflowers, you missed the end of the state's first part of their closing argument, which was really good. It was pretty much consistent throughout. Most of it was a walk through findings, not necessarily. I mean, there was all the evidence was included as well, but a walk through the findings of logically how this doesn't add up in their eyes. I think we'll get I want to see from her a very powerful close, a very, I wouldn't say drama filled and emotion filled, but I want to see something powerful from her, like hit a home run type thing. Sometimes it takes a year or more, and sometimes 0 tears like this. Alex here, who coldly killed. Circumstantial evidence is still evidence. Put the pieces together, shows the picture. And yeah, we talk about circumstantial evidence when we start with Marta, with Alex, another Alex Marta. There's a lot of circumstantial evidence. I think I was watching a couple other things on it last night, and I think he's got like 106 or so charges, mostly fraud, financial charges, against him right now. That are currently pending. Adds up to like millions and millions of dollars, possibly even $10 million that allegedly he stole from mostly his clients. And from his company, and you've got the murder of his wife and his son, and possibly 2 other people not being charged in this case, but there are 2 other suspicious deaths associated with him and this property that he lives on. But it's going to be a whole bunch of circumstantial evidence. Update your drivers. I'm not on Windows, Richard. I'm on a Mac. Everything updates automatically. Got more spicy maple bourbon pickles. Awesome, Golden Mom. I need to do that myself. Did the prosecution mention the security cam issues in closing? Not yet. Not sure if I missed it or if she didn't say it. No, I think they left that up to the defense to bring up, and depending on how the defense talks about it, I think they're going to hit it really hard. But the one thing I think they did miss on is the defense in the opening seemed to really push the issue and say, we think that Alexander messed with the cameras. He fiddled with it. He shut them down. He changed the sensitivity or something. That was like a big push on their end. And then the evidence didn't back that up. And that always looks bad when you tell the jury, you're going to hear that, he's guilty and he admits it in his own voice. And then if they don't hear that, the jury's like, were you lying to me? Is there a reason why I didn't hear it? Because it didn't happen. So that's always bad when they present something in their opening and then don't follow up with the evidence. Old dude says, all right, I tried the maple bourbon pickles. They are good and spicy. They're so good. Hopefully you tried them cold. Throw them in the fridge for a little while, at least an hour or so, and let them chill a bit. It makes them just that little bit crispier, and they are so good. A lot of spice, maybe on a sandwich. If the spice is too much, to just eat them plain like I do. One jar is a serving size, I believe. But if the spice is too much on a sandwich, it tones it down just a little bit. For real though, if I had multiple people in my house and I seen someone broke in, I'd be like, bro, shoot this guy as loud as I can. Either he's gonna get shot or they're gonna run. That guy, yeah. My response, if there was an intruder, I would probably make some noise. I would try to get attention to anyone in the house, either to have them run to safety or help in the attempt to subdue the guy. When I tear up, my voice gets all wobbly and I cry at everything, even greeting cards. That's not a bad thing. I really don't feel, a lot of people feel bad crying in front of people and feel, they're like, oh, sorry, I'm tearing up type thing. I think it's a gift to be able to feel and show emotion, especially to be able to feel emotion sympathetically for someone else. But that's a good thing. The footprints actually go down to okay, sorry, let me read this right, Kara. The recovery addict. The footprints actually do go out of the room only. Okay, so maybe when I looked at it, I was looking at it backwards. So did he crawl into the room? Was there any blood going into the room? And then there's a lot of blood splatter and then blood coming out? Because I think that's how I remember the picture. And the amount of blood probably is going to. I'll have to look at the picture again. I don't have it here, and I don't want to. I don't want to search for anything in case it breaks the internet. We'll have to do it after, during a break or something. Let's watch. Still nothing. We're just seeing the clock on the screen here. Let's see which feed am I taking? I'm taking 6. Okay. So this is the courtroom. It's still there. And my face goes away, and it shouldn't go away. I have to change a setting to do that. Okay, we'll fix that. I'm a Pisces. I cry at everything, says Shutterbug. Shutterbug said Jackson once removed. I'm looking forward to defense closing. I don't understand what his story is and the order of events in rooms. I think they've left some gaps, AJ. And that's probably the most consistent thing I've seen from the defense throughout this trial, even from the interview, from the 911 call. The little information they provided was a gap, a little here, a little there, a little there, and that might be his style. And I was hoping that if he did want to testify in his own defense, that he would get up there and maybe we would see and get to know him as how his mannerisms are, and that might be his way of speaking. And that would make more sense to me then. But where it is right now, it seems odd that there's just gaps. And then I was outside, and then I was inside, and then I was in my room. And it just, I'd like to hear just step by step, almost frame by frame type recounting of what happened. Is it histrionics? I believe the word is it's like a very vocal mourning. It's wailing. It's I think that's what it is. I just didn't know that was what the word was. Douglas, sorry. Denise says, I'm going off common sense. No one comes to a home and uses the homeowner's gun and shoots 3 people in the head and then leaves the victim alive to identify them. Yeah, you'd think that with each of the victims who died receiving a killing shot, a finishing shot to ensure their demise, it seems strange that one victim would be only wounded, and in a way that would almost guarantee their survival. I mean, that's like the mob is sending a message type thing, and there would be more evidence, I think, in that case. And then leaves the murder weapon. Yes, you've got that part. Of course, if they had gloves, then there's no concern about the murder weapon having fingerprints. He's lying through his teeth. That should have been knocked out by his dad. Mac, in my head, I think there was probably some yelling going on. I think there was an argument of some kind. The dad was interrupted and came to put him in his place or something, and the son probably did shoot him. I don't think it was like perched like a sniper waiting for him type thing. He probably made a decision to shoot, probably within that, a 30-minute period. I'd be surprised if he premeditated this beyond about 30 minutes ahead of time. He's a gamer and cares more about his hands. A broken finger may have been more devastating than a shot in the foot. Denise, would you have taken the stand if you were Alex, and if you were innocent, would you not want to tell your side on how you feel? Okay, Denise, if I were Alex and I were innocent, I would have a hard time not taking the stand. That seems like an opportunity for me to tell my story, that especially if it had not come out to that point, if I were innocent, there should be facts that line up with my story. As I witness the events, I should be able to articulate that in a way that says this happened and you can see that here. So if I were innocent, I would have a hard time not testifying, even though I know that it opens up the door for the defense, and the defense or the prosecution. They'd love it. You get up there and start talking. It's like, hey, we get to ask you all the questions we want, the hard questions, and bring up all the things in the past that, might make you look bad, that are sort of unrelated, but we can make it paint it look like, this is the motive. So yeah, it does open that door. But for me personally, if I were innocent, I would want to I would really have to fight that urge to not testify in my own defense. If I were guilty, I think he did the right move. There's very little good things that can happen with you standing up and trying to defend yourself in a court where you have nothing but lies to try to build on and to remember and recount. So that would be a challenge. We like pickles fried at our house. AJ, you just had a brilliant point somewhere about the hands. I don't think he was like a competitive gamer. Tish just came in with 5 subs, gift memberships. Sorry, and it looks like Barbara Williams, Deborah, Susan Bond, Christine D, and DH2 the JD. We're all gifted memberships. Thank you very much, Tish, for that, and congratulations to all the new members. Please take your seats as we get ready to start this round 2 of the closing arguments. Thank you very much. I'm going to go back and see what questions I missed here. Here's where I was. Nana Joe, good morning, by the way. Found out on Sunday, Mom. Oh my goodness, your mom passed away. I cried multiple times already, but a lot of it is internalizing my feelings and emotions. I don't typically cry in front of other people. Nana Joe, I am so sorry. My heart goes out to you. If we can be of any assistance, please know we're thinking of you and we're here for you. He had him on the grounds, could have just finished the job. Use his dad's phone to shut off the cam. That's assuming he had access to his dad's phone. And I'm not sure. I think they could probably be able to tell if he had access to the dad's phone. First of all, you'd have fingerprints on the phone, which would be pretty telling. Those screens really do leave fingerprints pretty well. I think they had some pretty new equipment. It was probably facial recognition on the phone. I was sitting in my little studio last night painting a sculpture of mine, and an idea about a sculpture popped into my head for you. If I can pull it off, I think you'll like it. I can't wait to see it. You are very gifted in your artwork, especially with cakes. Douglas, I don't cry. Yep. I went a long time without crying, Douglas. A long time. And then it built up like a dam. And then I had a moment of where the dam broke. And now I think I'm at a better level, but I don't cry very often. Sometimes I do. Sometimes it's just it's hard. Okay. Randy Rabbit says, I haven't heard of this case at all, but I don't have cable TV anymore. Yeah, this is there are some bigger cases out there. But this is one that we wanted to follow because it happened time-wise. It happened really well, as we are just about ready to pick up a very big case with the Murdaugh case down in South Carolina. So if we can get this wrapped up and have it done by dinner, that would be awesome. A quick verdict, whichever way it goes. Okay, we've got to do here.
Yes. And ladies and gentlemen, we're now turning it over to Mr. Johnson to make his closing argument on behalf of the defendant. Mr. Johnson, are you prepared to proceed?
Yes, Your Honor.
It was a concrete floor, 7. And
Is this okay, Kathy? Can you?
they looked for bullets, and they might have ricocheted
Check
and gone
1, 2, test.
who knows where.
Okay.
So it was
You may go
carpet
ahead
over
whenever you're ready,
concrete.
Mr. Johnson.
Thank you, Your Honor. Is it gonna come up? This is exciting.
Try this again.
Not the first one.
Okay.
Go to- Doubt is the absence of hubris. Certainty is the proof of it. Well, I don't know who made up that quote. I think what it means is that doubt is a natural condition. And doubt is what we ask of you as jurors when you evaluate the evidence in a case, is to look at it critically, use your common sense. Doubt, ask questions, because this is a case of circumstantial evidence. What that means
That's
is
where I thought
that
they were going to start.
even though the law makes no distinction, the evidence has to be so compelling as to remove all reasonable doubt. In other words, that there is no other possible interpretation of this evidence other than that the defendant is guilty. If there is any other possible interpretation, then the defendant is not guilty. And that is the consequence of a case based solely on circumstantial evidence.
Not any other possible, but it has to be a
Investigator
reasonable
Bosenberg,
possibility.
who stated under oath that he could not rule out an intruder. He was the one who investigated the crime scene.
The pole disappeared with the
And although
crash.
this is a horrific crime scene with 3 people tragically killed, it does not lower the burden of proof that the state must meet. So please do not let it inflame your passions or make you concerned that you should lower the burden of proof for the state simply because 3 people were tragically killed in this case. Because there are 4 victims in this case, and one of them is Alexander Jackson. So, as you saw in some of the crime scene videos of the body cams of these officers as they moved through this house, this is a family that took pride in their family. They were a great family. They took great pride in all the vacations they took, all of the things that they did together, trips that they went on, accomplishments that the kids did, and the Eagle Scouts.
Here come all the
picture of the
pictures.
family. There's Alex as an Eagle Scout. These pictures and pictures like this were all over the walls of this home. And as you listen to Ms. Slaughter this morning, the one thing that she didn't say is why. Why would Alexander Jackson kill his family? It makes no sense. This was a normal family. This was a happy family. There's simply no motive for Alex to do this. And no motive has ever been proven. When you look at what the state has to prove in this case, the judge has read the instructions and you've been handed them. Motive does not have to be proven by the state. They don't have to prove that. But when you try to make sense of the evidence in this case, you also have to do that in the context of this family dynamic. Of why? Why would Alex do this? He repeatedly told the investigators that he loved his family, that he wouldn't do this. Neighbors didn't notice any issues. Friends never noticed any issues. Teachers never noticed anything wrong. Scoutmasters never noticed anything wrong. They saw a family that participated in the family events, that interacted happily and normally together on the trips that they went on the scouting trips, and all the things of that nature. We heard testimony about Alex's character, that he went to Kennedy High School, that he graduated there, that he was accepted into the University of Iowa. He was an Eagle Scout. An Eagle Scout. Not just a Boy Scout, not a Cub Scout. He went on and went through all of the requirements for an Eagle Scout. He played flute in the top band. He was polite. He was respectful. He had no history of violence, no history of mental illness, and had never been in trouble before. When the prosecution talked to you just a little while ago about his fingerprints, they only had his fingerprints because they arrested him. They did not exist prior to that in their files. When you look at this neighborhood and you think, as we heard from police officers, not a lot goes wrong in this neighborhood. When you look at this neighborhood, if someone was going to do a home invasion, this would be the perfect neighborhood for it. It's affluent. Those are affluent homes. They're large. They're spaced out. The homes are spaced out away from each other. They're surrounded by wooded areas, and they're secluded, relatively secluded for an urban area. And as we saw, particularly in the Jackson home, the dog did not bark when the police arrived. I think on one of those cameras, you heard the dog go, woof, just one time. If you listen carefully, you can hear it. But I don't know about you, my dog goes crazy when anybody comes anywhere near the house. There were no cars in the driveway, and there were multiple guns in this home. Now, we don't know what the intruder's intent was or why they were there. May not ever know. But it could have been because there were firearms in this home. There was a case years and years ago, which was the subject of a famous novel, In Cold Blood, where a home was invaded in Holcomb, Kansas, because of a rumor that the guy kept $10,000 in his safe. This was back in 1950, so that was a lot of money. And because of what happened in that instance, when these two guys went in and killed everybody in that house, it became a very salacious story that Truman Capote wrote a novel about.
But he didn't kill everybody but one in the house.
These things happen. Home invasions happen. They happen, unfortunately, all over the country. And they happen for motives that we don't always understand. There isn't a shred of evidence in this case that disputes anything that Alexander Jackson said happened. Alex said he was sleeping on the porch with his dog. There's bedding that was found in the porch. He was sleeping there, and he heard shots. That was his testimony. Now, was he sleeping? Was he on his phone? He was definitely on his phone at 6:53 in the morning, searching for who played the Emperor in Return of the Jedi. Did he fall back asleep? Was he messing around on his phone? Did he drift off? Kids do that. But he was awakened to the sound of gunshots. And he had his phone with him on the porch. He hears the shots. Now, a lot of us would like to think in an emergency situation that we would act immediately, that we wouldn't freeze up, that we wouldn't be scared. But maybe Alex was. Maybe Alex froze. He hears the shots. He hears more shots. And he's afraid. And he hears somebody moving about through the house. He hears a number of shots. He estimates 10, I think, at one point.
And he doesn't
But,
call
he's
911.
not counting them
He's sitting there with
exactly.
his phone.
And he can hear someone moving through the house. And then it stops. So Alex either goes down the porch steps outside the house and comes back in through the back, or he comes around and goes down the steps inside the house. And what does he see? He sees a man standing over his father. And Alex runs at him, and a struggle ensues. Here's the important fact about the shell casings in this case, ladies and gentlemen. The first 4 were found, now we're assuming these are the first 4. Right there, right behind that area there is the back door. The back door would be right here. This is the back of that sofa. 4 shots fired in that area. That's where the gun drops those casings. 5 in the master bedroom. You got that one? It's okay. You remember from the testimony there was five shell casings found in the master bedroom.
I'll have to get that to where.
And there were 2 shell casings found in the sister's bedroom. What's that add up to? There's 4 of the 5 in the master bedroom in State's Exhibit 104. There's the 5th one in State's Exhibit 108. And then there was 2 shell casings. There's number 37 found in the sister's bedroom, Sabrina's bedroom, and number 19. That adds up to 11. Now the shooter is out of bullets. And I would submit to you that the order must have been when that person came in to the house. He sees the gun there. Does he have knowledge of firearms or not? We don't know. But he sees the gun there. We don't know how long it took him to load it, if he had to load it. If it wasn't already loaded, we don't know that. But maybe he has some knowledge of firearms, or maybe he took the time to figure it out. because we don't know how long he was in there before he was discovered. Jan Jackson is moving around. As the state said, Jan Jackson is awake. He sees the person or hears the person and comes running down the stairs. That's when the intruder fires off 4 shots at Jan Jackson, missing him 1 time into the wall. That's why those 4 casings are there. Then the intruder goes upstairs from the direction that Jan Jackson came and shoots the mom, shoots Melissa 5 times, shooting these people multiple times. That's 9 shots. He comes back downstairs to look for anybody else. And he goes past Alex's room. Alex isn't there because he's on the porch. But now Alex is starting to move. Alex is starting to come around to see what's happening. And he shoots Sabrina. He's going to shoot her 4 or 5 times, this intruder. But he runs out of bullets. He's only got 2 left. That's why she was only shot twice. That's when he goes around, he's reloading the gun. And why is he reloading the gun? Because Jan Jackson isn't dead yet. Jan Jackson is still making sounds. Jan Jackson is still breathing. So the intruder reloads. As he's doing that, he goes over and he shoots Jan Jackson twice. As he's standing over Jan Jackson with those additional shell casings that we find next to Jan Jackson's body, Alex surprises him. Alex comes up behind him, either from outside, going down the porch steps into the basement, or coming around from the stairs. I believe he must have come around from the basement that way because the shooter would have his back to him as he's shooting the father. As he's killing the father, making sure the father is dead, that's when Alex surprises him. And that's when Alex gets shot in the foot with that struggle. Because the man has now reloaded. 2 shell casings are found on either side of Jan Jackson's body, and 1 shell casing is found next to the gun that's lying on the ground. But we could get to that next. I want you to look at this, where this foot, the hole is in Alex's foot here. See where it is? See where it is on his foot, because this is going to be important in a second. Can we go to the next shot then of the hallway? This is the hallway. This photo is State's Exhibit 72. You see this blood right here? This is where Alex got shot in the foot. Not in his bedroom. The evidence will show that this is where he got shot, because this is where the gun is. This is where the shell casing is, but more importantly, the footprint. If we could zoom in on this right here in the middle of the screen.
Okay, there might be some images
right
here.
Here. Look at that print. I don't know if you can see it. That print has a foot with a hole in it and blood coming out. Right there. Right there. Pointing in that direction. As if somebody got shot in the foot there with this blood here, and you can follow these footprints all the way down that hallway. There's 2 kinds of prints, ladies and gentlemen. When you look at the hallway photos, there's 2 kinds of prints. One before a shirt is put on his foot, and one after a shirt is put on his foot. And you can tell because there's a gap. If we follow down this hallway here, these are the 2 trails I'm talking about. This is the one where he already has the shirt on his foot. This is the one that is this one. There, 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 there. He is making his way.
I hope the jury can see because we can't.
To get a tourniquet for his foot. So he goes in to his bedroom. Here, this is good. This is a close-up shot of that. There's the print with a bloody extra blood deposit where the hole was in Alex's foot. He's going this way. He's heading towards his room. And this is after he comes back out. This is his print with the towel on, with the shirt on. Can we go into the bedroom then? This is the buckle.
Okay, so
that he used to try to make a tourniquet with, that he told the police, and it broke. Next picture, please. This is his bed. This is where obviously
that's a stretch for me.
There's a pool of blood here, which would have collected while Alex tried to put a tourniquet on his foot.
I think that, to me, right here, if I could pause,
that blood bleeding out
that
from
tourniquet
from that
and a lot of
hole in
blood
his
right there,
foot.
if he had
Right there, where it
successfully
was
attached
he
a
rested on the
tourniquet
side
and
of the bed
stopped
as
the
he sat on
bleeding
the
for
bed.
just a moment,
Now,
and then
did
it
he
broke,
hop into his
there would have been a
bedroom?
gush of
And that's
blood
why
like
there's
that.
not a print going in that direction? We don't know. But what we do know, can we get the next shot? Here, as you can see, after he's tried the tourniquet, after he's put a shirt on his foot, that happens. That print happens. Can you blow that up a little bit, please? See the gap here? The gap in the bloody print. That's where the shirt was wrapped around Alex's foot. Can we go back to the hallway now, please? And now you see the effect of that shirt, and you see the gap on his footprint right there. Coming back this way to check on his father. How do we know that it happened this way? Well, we don't, but it's a fair interpretation of the evidence. But let's consider what the state thinks happened. Can we pull back to that original shot? Is there another one that has a gun in it? There, right there. Are we to believe that Alex took that gun all the way into his bedroom, shot himself in the foot, then covered up his bloody foot with a tourniquet, and then picked up that gun again and drug it all the way back there and left it right there? That gun would be covered with blood. And it's not. There's no blood on this gun. This is where he bled. The gun falls here. There's a shell casing right there. There are 2 shell casings on either side of Mr. Jackson. And that's because that's where the killer was shooting Mr. Jackson when Alex surprised him. Otherwise, can we go back to that one again? The further one. How else does this blood get here? If it wasn't from the conflict with the intruder and he gets shot, how else would this blood get here? Was Alex supposed to come all the way back up here with the gun and then stand there and bleed? Take the tourniquet off and bleed there? That makes no sense. That's the first print he makes after his foot gets shot, before there was a bloody shirt put on it. No shell casings were found in his bedroom. There was a shell casing behind the couch, number 13, which we've talked about. Now, there was a lot of testimony about no signs of a struggle. Well, there was no sign of a struggle either when Jan Jackson fell down the stairs and landed where he did. He just didn't fall into anything. We don't know if that couch was moved or not because they never picked it up and looked to see. Maybe it did. Maybe it got lifted up and it came back down. But there's nothing else to knock over right there. There's a struggle right there. And sometimes there aren't signs of a struggle. But there is a visible path from the living room to his bedroom. And the state's theory that he shot the sister first, which I think might have been raised earlier in the case, makes no sense. Because if you were to shoot Sabrina first, twice, you wouldn't run all the way from here, all the way past where Mr. Jackson would be coming down the stairs, all the way around this sofa to take up that position where those 4 shell casings were found. That doesn't make any sense. That's why what makes sense is those 4 shell casings by that back door is where the killer came in. That's where he came in. That's where he found the gun. That's where he loaded the gun, difficult as it may be. And then Mr. Jackson comes down the stairs and he shoots him. And again, the number of times that Sabrina was shot would indicate, I would argue, that the killer was out of ammunition at that time.
The killer was out of ammunition at that time?
Yes, we obviously would agree that that weapon had to be reloaded. On the 911 call, do we have that first? Can we play the first?
I struggle with the part where they say, we don't know if he came in the front door or the side door. It's like, it's your client, ask him, at least have a story picked out instead of presenting, he could have done this, he could have done this. That seemed weak to me.
I'll be impressed if this works.
You should not be impressed if your
That's okay.
defense presentation works. You should have this
Forget it.
polished and ready to go, like my live streams every morning.
Lynn County Sheriff, where is your emergency? Someone broke into our house. Our address is 4414 Oak Leaf Court, Northeast. I've been shot. My other family member's been shot. I need help immediately. Okay, I'm getting Cedar Rapids on the line here. I've been shot in the
They turned the volume all the way off.
Okay, sir, stay on the line. Be answering. Give them the address right away.
911, what's the address of the emergency?
4414 Oak Leaf Court, Northeast.
Okay, what's going on?
There's someone broke in.
Okay.
I've been shot.
You've been shot?
My dad's been shot.
Okay, thank you. That wasn't great sound quality, but what he says on that first call is, I've been shot. My other family member's been shot. Now, the big difference between a possessive S and a plural S would be if you were talking about all of your family members, you would say, my other family members have been shot, not my other family members been shot. That's the possessive use of the S. In other words, my family member, his father's been shot. And that's clear from the rest of this call. When he talks about he's been shot, his father's been shot, my other family member's been shot isn't a reference to everybody. It's a reference to his father. You can tell by the context of the way that's used and by everything Alex says after that. He talks about his father being shot. He doesn't know how his sister is. On the ambulance ride to the hospital, Alex was worried about his family. He says, is my sister okay? And that's about the 8:56 mark. At the 8:59 mark, Alex says, did they get an ambulance for my dad? And at the 9 o'clock mark, did they get an ambulance for my dad? Again, he asks. And you can see that he is crying in the ambulance on the way there. Obviously, Alex is in pain. He's in shock. He's given fentanyl on the ambulance. The male paramedic says, okay, what number would you give that pain? 10 being the worst pain you've ever felt in your life. And Alex says, probably a 10. And again, Alex was given fentanyl, and we heard about what fentanyl can do. So then Alex is taken to the hospital, and the 4-hour hospital interrogation begins at that time. This is a picture of Alex when he gets there at the hospital. You can see in his eyes the shock and the terror. You can see his condition with his foot. We heard testimony about the effects of trauma on memory, and we heard those from Investigator Denlinger, because he knows the effects that trauma can have on people's ability to relate a story rationally and concisely and appropriately, that trauma can cause confusion. Trauma can cause memory lapses, and we know that because the Cedar Rapids Police has that very policy for their officers. Officers involved in traumatic incidents must be given up to 72 hours before they have to make a statement to anybody. And that's because of the known effects of trauma on people's ability to relate things that just happened. Add to that the effects of fentanyl, which Dr. Cruz said can cause euphoria and can cause confusion. You add those two things together and you have somebody who is most likely disoriented and is not there, as Timothy Brown stated at 9:08 when he hands off Alex to investigators Denlinger and Lucina. He says, he's not there right now. And Sarah Lucina says, yeah, I can tell. And then at 9:29, the female hospital staff worker says, can I give him pain meds? And Sarah Lucina says, is your foot real bad? Do you think you can hold off on pain meds for maybe 15 minutes for us to talk to you? Can you imagine if you were Alex's parent in that situation? Would you stand for that? Would anybody stand for that? Denying somebody pain medication while they ask them questions. And these aren't questions designed to find out who the intruder was. These investigators were on Alex in minutes because they didn't believe there was an intruder. This is before they'd even been to the crime scene. This is before they ever knew anything about any cameras or dog tracking or anything. They were on Alex. Yeah, sure, they acted nice, but the most important thing is Alex was nice. Alex was polite. Everything that people said about Alex, he demonstrated in that interview, in that interrogation. He was polite to the officers. Even when they insulted him, he was polite to them. When they show up, this is the part about the fentanyl being administered. When they show up at 9:16 and start talking to Alex, Sarah Lacina says, "My name is Sarah, and I'm an investigator with the police department, and this is my partner, Matt. He's an investigator, too, at the police department." And Alex says, "Oh, good." He doesn't know what he's in for. He doesn't know the kind of grilling that he's in for. And then he gets another dose of fentanyl. And Alex says, "What is that?" And the female hospital staff says, "Fentanyl, the same medicine they gave you in the ambulance." 3 minutes later, under the influence of this drug, Alex says, "My mom is here," or you can hear that at 9:47 on the interview. I asked Investigator Denlinger, and he agreed that that's what Alex said. At 10:14, when it becomes obvious to Alex that they're directly accusing him of this crime, he says, "I didn't do it, okay? I would never hurt my family. They're important to me. I love them. You may not understand that, but I love them." Then comes the false accusations about the cameras. Denlinger says, "So at what point did you unplug the camera?" Alex says, "Unplug what camera?" Matthew Denlinger says, "Your camera." Alex says, "I don't know how they work. They're also hooked up to the garage. I don't know. They're also wireless." Meaning, how can you unplug them? They're wireless. And then, in response to an allegation that the alarm system had been disabled, Alex goes, "Oh, there's no alarm system. There hasn't been for years." And Denlinger says, "There hasn't been for years." At 10:09, Sarah Lacina says, "And that's what I mean. That's why I want to know, is because you're adamant that you would never, but the evidence is pointing towards that you did." And Alex says, "Well, can't you do some lab stuff?" He wants them to do more investigation. He's not acting like somebody who just slaughtered his family. And here's the thing, ladies and gentlemen. He's in shock. He's under the influence of anesthetic drugs. And so it will be easy for people to sit back and say, "I'd have been more upset than that. I'd have been crying more than that. I'd have been shouting out for my sister back at the house, 'Sabrina, Sabrina.' He's been shot in the foot." He is in shock. He doesn't know what to do. But for us to sit back and Monday morning quarterback what he said and how he said it, when he's in this condition, when he's sitting in a hospital bed, bleeding out of his foot for 4 hours while they do nothing to help him, while he's been given pain medication, to judge his responses and the way he said them and the accuracy of those things is tantamountably unfair. We wouldn't require that of any of us under those same circumstances. And they chose to do that then. They could have waited. They could have given him time to recover. They finally did after they made all their allegations and after Alex got treated at the hospital. But that was several hours later. And that's, again, where Alex mentions again about the lab stuff. And Investigator Denlinger says, "I mean, the best evidence in a case like this is not going to be the lab stuff." And Alex says, "Well, I think that helps." Apologize for the typos there. At 10:12, Alex says, "Well, I was, because I went to my room to grab a belt, but it broke, so I wrapped it in the closest thing and stuff. Not to go get his phone, to go get a belt for a tourniquet." Now, maybe he said at a different part of his interview, "I went to get my phone." But again, you have to put this in the context of someone who's just been shot, someone who's been medicated, someone who's been traumatized. Are they going to get everything right? I don't think so. But at least at one point, he said that he went to his room to get a tourniquet, and that is supported. That is supported by all that blood evidence in that hallway. And they said, "Okay, and then did you go into your mom and dad's room?" "No, I haven't been there for a while." Not once did Alex say he ever saw his sister or his mom gets shot. At 12:19, Alex says, "My parents were good to me. I'll say that now and forever." And that was at the end, more towards the end of this interrogation. But they kept trying to give Alex a reason. They were grasping at straws, trying to come up with a reason. Oh, you didn't like your sister. Oh, you weren't close enough with your sister. You didn't like your dad. You didn't like your mom. Oh, the Menendez brothers, they killed their dad and their mom, and then they later claimed it was because their dad was abusive. And Alex goes, "I will never say anything bad about my parents." Alex described cleaning the gun that night. "Well, I've got the ramrod thing. I know we put that back at least I put it back in the exercise room." And Investigator Denlinger says a few minutes later, "No, I'm talking about earlier in our conversation. You talked about you were not sure where you left the gun, but it wasn't on the fireplace." And Alex said, "I think it was because my dad was still looking at it or something." And Investigator Denlinger says, "You said the gun was not left out on the fireplace where you cleaned it." Alex says, "It was left." And Denlinger says, "Okay, it was left on the fireplace." And Alex says, "Yeah." At 8:53 p.m., after Alex was discharged from the hospital, he was taken to the Cedar Rapids Police Department. And that's where he made the comment about his parents and that they don't usually lock their doors. And then Denlinger says, "Well, what's your sister's password for your phone?" Is it Daddy's favorite #1? Which was one of the last in a long line of disparaging remarks that Mr. Denlinger made about Alex during the course of that conversation.
That's actually good police work.
He said, "Who's going to support your Chick-fil-A habit? What are you
trying
going
to
to do,
rile
get a
him up
job
and get a
playing
response
Halo,
that he's not
being the #1 guy on
prepared.
Halo?" Through all of it, Alex was polite. Through all of it, Alex didn't reciprocate. Through all of it, Alex denied killing his family and wanted them to do more investigation. Can't you look around some more, he said at one point. Can't you do some more investigation? We heard some testimony about the dog, Corsa. Corsa's a good dog. She's been trained in tracking. She's been trained in explosive detection. And we had a dispute about whether dogs could smell disturbed vegetation or crushed grass. And Mr. Scheer tried to ask Mr. Hyen about a couple of studies. Didn't show them to him and asked him about them. And Mr. Hyen had never heard of any studies that said that a dog can smell human odor and crushed vegetation. It doesn't really matter for this case. It's just an example of how Officer Buckles doesn't know everything that he's talking about when it comes to dogs. Mr. Hyen does. He used to, before he changed his jobs to doing what he does now as consulting. He's been all over the world, Mr. Hyen. And he evaluated Officer Buckles' job of tracking and found a number of problems with how Corsa performed and how he handled that dog. Why does this matter? Why does this matter? Because if you're going to claim that you didn't find a track, in other words, the absence of a thing, then you should do the tracking correctly. And it was Mr. Hyen's position that Officer Buckles did not do the tracking correctly. One of the reasons was the dog was panting so badly. And Officer Buckles' own training logs showed that Corsa had a history of panting, and that would interfere with her ability to smell. Corsa had no tracking experience over gravel. And if a dog can smell human odor, then you could track her over concrete. Did Officer Buckles once try to track that dog over concrete? No, because he knows. And this track is 40 minutes old at best. Now, Corsa did locate some tracks where officers had been before, but they had just recently been there. I mean, just recently, just within a couple of minutes. So that plus the fact that they had been through the backyard, as Mr. Scheer pointed out, had contaminated the scene for a dog to smell an independent track. Dogs can't distinguish between one track and another, except in terms of the age of the track.
Seriously?
And if the
I don't buy
dog
that.
isn't on the track, it's not going to smell the track. It's not going to be standing 20 feet away and go, oh, the track is over here. You have to bring the, what Mr. Hine is saying is they don't leave that you can smell 40 minutes later. Of the Ring camera, what we're looking at here on the in this lower picture here is the Ring camera recording the police activity on January 5th. Police activity on that day, except for the back camera. That's what the police wanted to find out, is the back camera not working properly. When the warrant went out for the Ring camera system, it was supposedly supposed to be over a 3-day period, as the testimony said. But over a 3-day period, you get one view of the backyard. That outstripped its motion detecting. And so it had a sporadic motion activation system. And when we had Mr. on the stand here, he said that all the cameras were offline when he subpoenaed the records for the 17th when they did that test. That's why they didn't return any data on any of the cameras, because they had gone offline by then. But that wasn't the case on the 15th. They were working. Those cameras were working. We have the...
Do we have the video? We should.
So, what are we seeing here? This is the day before. This was in, I think the testimony was late afternoon. There's Alex. This is the whole backyard. It's right up here. Right, that's the camera angle. Right in the lower right-hand corner, the camera would be just off.
So this one's working. Let me check the other
Alex
one.
doesn't even show up on that camera till right there. All of the activity that went on through the back door is way over here. Now, why does that matter? If we assume that Alex goes back to where he came from, we don't know, because the camera didn't pick him up till he was way over here, where no intruder might have ever been. But if we assume that Alex came from over here, can you play the rest of this clip and then the next one, please? Clip and then the next one, please. There he goes. And then on the next one, you see him the whole time coming back.
I don't know why it's going fuzzy like that.
And he's going right back up there where he came from. Motion detector didn't catch that on the first shot. So there's something wrong with the motion detector on that camera. Now, they want to make the allegation that Alex messed with this camera. There's no proof of that. His prints weren't on the camera. There was nothing wrong with that camera. It had a battery in it, and the battery had charge in it. There's no proof that Alex ever had the Ring app on his phone. And they try to suggest that in the testimony, that Alex could have messed with the phone, with the camera. But want to look at it. Well, they'll make the allegation. They'll make the allegation that he messed with that phone without any evidence whatsoever to support that. And so then what happened? Investigator Holst went and looked at it and said the exact same thing our guy said. Same thing Mr. Lyon said. Here's the two incidents where the Ring app was last used by the parents. Nothing on the kids' phones, which would be consistent with the fact that the kids had nothing to do with the camera system. That's the parents that do that. And this latent print, number 3, which is shown here in Defendant's Exhibit G, that looks a lot bigger than a centimeter to me, but I'm no expert. Looks like we got at least 2 centimeters on there, and it goes way down here. Here's the thing about that latent print that we went around and around with Investigator Bosenberg about. It is one thing to match a print. It's another to exclude someone. You don't need the same amount of information. You need several points of comparison to say, you don't need the same amount of information. You need several points of comparison to say, this is a match. But all you need is an inconsistency to exclude someone. Don't tell me that you didn't take that print and compare it to Alexander Jackson's to see if you could exclude him. That would matter. That would be important. And I believe that was done. It would make sense. It would be logical. And then he only submits this print for identification into the state database. What if this print is the print of the intruder? What if this print comes back to somebody who had no business being in that house? What if that happens 20 years after Alex has done 20 years in prison? Are we going to apologize to him then? This print is very important and should have been pursued. Should have been pursued by people who want to know the truth. So the DNA evidence, you are going to hear me talk about DNA. And that's because you can get DNA from a lot of sources: sweat, blood, saliva, and touch. And why is that important? Remember, there was some discussion about that Idaho case. They found that DNA in one little place, and it broke the case wide open. If it hadn't been for that, investigators like Denlinger and Lucina would have been all over that
This
roommate
lawyer wants to be on
who
the Idaho
survived,
case.
as if they were the one who had done it. Because there's no proof that anybody else was ever there. You have to look before you can say there's no proof. There is proof. There's proof in the physical evidence at the scene. There's proof on that gun. And maybe some of this DNA would have turned it up. But they don't want to know that. They don't want, that would be bad news for their prosecution. There were many areas on the gun that wasn't tested. And there was, they didn't even test the swabs they did of Alex. Not his hands, not his legs, all that swabbing that you see going on early. They never test any of that. But most importantly, with the gun, with how many rounds it holds, that matters. That Nibin report that said that they were 22 shorts, if those bullets were 22 shorts, then you wouldn't have to reload. But we found out they weren't. They were 22 longs. Did the experiment. So what does that mean? That means that those 3 shells that were still in there that hadn't been fired had been touched by the killer. And those were never swabbed. They were preserved. They were dropped out of that gun. They were preserved, but they were never swabbed and never sent to the DCI. That is just like that Idaho case. That is the same kind of evidence. That sheath, that knife sheath that they found in that case was the killer's. So that little print on there, or however they lifted that off, that snap on that sheath, belonged to somebody who didn't belong there, and that's how they broke that case wide open. They could have done the same thing with the bullets in this case. Alex's clothes were tested. Only Alex's blood was found on his clothes. No blood from any of his other family members were found anywhere on any of his clothes. We heard some testimony about a neighborhood canvas. And the court already read you the instruction on that. Officer Barber interviewed the workers, I think. Investigator Dunbar interviewed some neighbors. That's not evidence. What they said, those people said, is not evidence and is not to be considered. They didn't call these people as witnesses. They didn't call the workers. They didn't call the other neighbors. And so that evidence is not to be considered by you, what the officer said. It was only offered to show why the officers went to certain places. But the substance of what those people said, the testimony, what the officers claimed those people said, is not evidence. Remember when Investigator Dunbar was on the stand and he was talking about whether or not the people from Usher's Ferry ever got back to him? He was about to say they did, and then he corrected himself. And that's the reason why this kind of stuff is unreliable. But the court is specifically instructing you. If those people had testified, we'd have been able to ask them questions like, were you looking in this direction? Were you looking in that? What were you doing when all of this happened? And then the statements made by the police in their interrogations and their tactics, what they say to people, what you hear Investigator Denlinger and Investigator Lucina say, that is also not evidence. It's only to be considered in terms of Alex's response to those questions. We heard the state fish around in this case for some sort of a motive. Was it in inheritance? They have no proof that Alex would inherit. They've not testified about a will, whether there is a will, whether there isn't a will, what it says, or whether Alex even knows. There was some question about the sister being bisexual, that somehow that would be something motive for Alex to kill his sister. Well, you hear Alex later in the interview when they start questioning Alex's sexuality. Alex said, I'm not, I'm straight, but if I wasn't, my parents would be open to that. He says that right in there. It's not a motive. His grades dropping during COVID, that's a reason to kill your whole family? Or he didn't have a job? How many kids didn't? How many kids had their grades drop during COVID? And Alex said that his father was treating him fairly, that his father was letting him make his own mistakes. When I started off talking to you about reasonable doubt in this case, I gave you the Tylenol example. And the purpose of that is to say that even though a doubt can be small, it can be reasonable. And the only thing that you have to believe in this case to make that reasonable is that somebody could commit a home invasion and have some working knowledge of a firearm. And if that's impossible, that's your decision, I guess, because you are the judges of the facts of this case. That's why we stand up when you come in, and we stand up when you go out, because nobody can tell you what reasonable doubt means to you. That's why we have 12 of you. You're all going to have different attitudes or opinions. But when you look at a case that involves circumstantial evidence, if all you got to believe is that somebody broke into this house and used the firearm that was sitting right there, and they knew how to operate it, that's not such a stretch. That's not so hard to believe. Maybe it will be for some of you, and that would be your right to feel that way. But would you be betting would you take that Tylenol? If that's all it took?
Or drink the
taking the
Kool-Aid?
Tylenol out of that state's case in this case? Because if you're not, that's reasonable doubt. We believe that reasonable doubt is all over this case. Alex had no reason to want to harm his family. And we would ask that you return a verdict of not guilty. Thank you.
Okay, so I will say that he did a good job of not getting too dramatic in that he tried to stick to more like a factual type presentation. Prosecution gets one more crack at
Ladies
it.
and gentlemen,
That's
before we
what were waiting
proceed
for.
with rebuttal, why don't we just stand up real quick?
Oh, it's yoga time. Everyone turn around, shake hands with somebody you don't know, introduce yourself, ask them 5 questions.
All right. Ms. Slaughter, do you have a rebuttal argument you wish to make? All right, you may go ahead. Do you need the AV system? Okay. All right, well, just let me know, obviously.
Pop them hips. I think that's what he was doing. Here, let's see how she does. I think she's going to come through with a little more power. Hey, Christine, good to have you here. Hope you enjoy it. It's right at the end of this trial, but we're going to listen to this part here.
This is a case of circumstantial evidence. It's what Mr. Johnston said when he stood up here in front of you. I don't disagree with that. DNA itself is circumstantial evidence. It says that someone's DNA is there, but it doesn't tell you how it got there, right? That's what circumstantial evidence is. It's evidence that does not have that direct source that someone's going to sit up there and tell you that they heard it, they saw it. That doesn't make it any less effective or any less true or mean that you give it any less weight. We said that in the beginning, that you as jurors get to evaluate the evidence and that you get to put the amount of weight on any one given piece of evidence that you want to put on it and use that to paint the picture. There's circumstantial evidence in this case because no one else was there to see the defendant murder his family. One important factor in this case that everybody keeps talking about is evidence and what evidence existed. But let's not forget that the absence of evidence is also evidence. And ladies and gentlemen, there's a whole lot missing from those cameras. And there's a whole lot missing from those cameras because there was not an intruder. The defendant wants you to believe, ladies and gentlemen, that sometime during the early morning hours of June 15th, 2021, the black guy in all black with a ski mask and gloves and green shoes is lurking around this secluded cul-de-sac full of affluent people who are out walking their dogs and enjoying their morning, and no one saw him. And no video cameras picked him up, including the 4 video cameras attached to the Jackson home and the camera across the street that live streams everything. It doesn't stop. Investigator Denlinger told you that he watched 6 hours of footage from the Nest camera from the Yang house, and there was nothing. We can go back and forth about what happened to the backyard camera. We looked into it. We can't prove it one way or another. It's very coincidental, though, that the one camera in the Jackson household that could confirm the defendant's story about the random black guy in all black with green shoes and a ski mask and gloves made it to that back door and didn't get picked up on the camera that caught Alexander Jackson walking the exact same path the night before. I don't know what happened to the camera. We couldn't prove it. Had experts look at it. They analyzed it. For whatever reason, it didn't work. But that's coincidence. None of the other neighborhood cameras found this person. And then Mr. Johnston stands up here, and now the story is that when the defendant heard the gunshots, he ran out the back door and came down the steps and then went around to the back door and in, and that didn't pick him up on camera either. Mr. Johnston made a big deal about the state not being able to prove motive in this case. When you look at your jury instructions and you look at the elements of the crimes that the state is required to prove, motive isn't on there. Motive isn't on there, and the state is not required to prove motive. We can lodge some guesses. He talked about being the kid home from summer vacation and his dad wanting him to get a job and him getting ready to be kicked out of the house. And if he doesn't have a job, then he's out with $30 in his bank account. The oddball of the family, the black sheep of the family who stays up all night gaming with his friends is suddenly going to have to step into the real world and get a job and be a man. Motive? The fact that he only has $30 left over, is the money the motive? Is the fact that he's going to inherit houses and assets and all of that, is that motive? I don't know, but guess what? I don't have to prove that motive. No matter what motive, no matter what reason that the state would present to a group of rational-minded jurors is never going to be motive enough for you to think, gosh, that's a good reason. That's a good enough reason why this kid killed his parents. There's never going to be a good enough reason Alexander Jackson executed his entire family. Mr. Johnston wants to talk about murder cases that happened in 1959 and, motives there. And how many murders do you hear in the newspaper or on the news as his source where there's never a motive why a school shooting happens or why this or why that or why some kid decides one day that he's going to walk into a building and execute kindergartners? It's never going to be a good enough reason to kill your whole family. That's why we don't have to prove motive, because it's irrelevant. The defendant on this fentanyl is so doped up and euphoric that he can't form thoughts. Ladies and gentlemen, you get to see and hear how the defendant responds and how the defendant reacts when he's at home laying in that hallway with his foot wrapped up. You get to hear his tone of voice. You get to hear how he answers every question with a question and the weird inflection in his noise. That doesn't change before the fentanyl or after the fentanyl. The idea that 320 pounds and 100 mgs of fentanyl is going to make him so ill-lucid that he cannot form rational thought and he can't explain to you the details that just happened. My family was just executed. My dad is laying in front of me in a pool of blood with gunshot wounds, and I can't tell you any more than that limited information that he just gave. That makes no sense, ladies and gentlemen. The only person that Alexander Jackson was worried about on June 15th was himself, because he slips in a couple sentences. Is my mom okay? Is my sister okay? He never had concern for his father. He never checked on his sister. He never checked on his mother. He never called out their names. He never crawled an extra 4 inches to peek around the corner to see if his sister, whom was laying in bed, was okay. Never tried to resuscitate his father, never shook him, never told the 911 caller, listen, it's just my foot, who cares? My dad is laying here dying, if not dead. The only person that Alexander Jackson cared about on June 15th was himself, ladies and gentlemen. And that's because he killed his family members. He has to make himself look like the victim. There's 4 victims in this household. There's 3 victims in this household and 1 murderer. And that murderer is Alexander Jackson. Mr. Hyen. Mr. Hyen basically took the stand and said that none of the K-9 units used in police agencies across the United States are any good, because that's not how he learned it in Germany back in the 1990s. He doesn't think that he should be certified in any of the certifiable programs that are used by law enforcement agencies across this country, because he just doesn't think they're good enough. If you look at Mr. Hyen's CV, his curriculum vitae, which is the same thing as a resume, any notable experience that he had was in the 90s. 90s doesn't sound like that far away when you think about it, but that's over 30 years ago. He wants to say, oh, there's a couple things missing from the early 2000s, but he also said that if it's not written down, it doesn't exist. You can't even keep your resume up to date, and you're coming in here testifying as an expert witness because some dog class that you took in the late 80s and early 90s tells you that German dogs do it better than all of the police forces and in the United States do it. It's a joke. He contradicted himself so many times that I don't even know what his testimony was. In 1 minute, he's saying, this is where the entry point to the backyard should have been. This is where Officer Buckles should have started that track. And then he points at the area that was most heavily contaminated by EMTs and law enforcement agencies. And then he says, well, the dog can't smell human odor. The dog can only pick up vegetation. It's too hot for the dog to do any tracking. Wait, ladies and gentlemen, right here, Officer Buckles is pulling the dog away from a verifiable scent. You can see the way the dog puts their nose down that they smell something. Well, which is it? The dog can't smell or the dog can smell? Then he says, again, as the dog gets closer to the house, it's too hot, and I quote this, it's too hot, it's dangerous for the dog to be working in this heat. Not 2 seconds later, he says, look how the dog picked up that track, but we're not going to count that track because that's a contaminated area where the officers went. Dogs can't trot across concrete, and dogs can smell illnesses. Dogs find people buried under rubble after explosions. Dogs do all of these amazing things, which is why they're used. But because Mr. Hyen got a training class in the 90s from Germany, we're just supposed to discredit all of the K-9 work, both medical and emergent and law enforcement that K-9s do in this country because Mr. Hyen said it's not good. Stop it.
This is a good time to make an objection because she's on a roll, even if it's just a BS objection. You want to slow this down. She's captivating as far as a speaker goes. Whether or not you agree with her, she's got a style that is easy to follow. She's leading well. She's connecting the dots and bringing them down a path to where she wants them to reach. So objection is probably going to be overruled. Either way, she's going to move on.
The common sense that Mr. Johnston talked about, that I talked about, the version of events that the defendant wants you to believe in this case is an insult to common sense and to reason. The defense stood in front of you and talked about if there's two differing stories, then that's doubt. I submit to you, ladies and gentlemen, that in any criminal case, unless you were there to see it yourself or the entire crime was captured on video, there's some doubt, and there should be. And that's what you as rational and reasonable and commonsensical jurors get to analyze and decide.
There was an objection. We don't know what it was. Something about the style.
But reasonable doubt, and we talked about this in voir dire, reasonable doubt is more than the mere possibility of doubt or the mere possibility of innocence. Possibility doesn't make something reasonable. What the defense wants you to believe in this case when they're arguing reasonable doubt, in order for that theory or those theories to create that reasonable doubt, is a couple things. First, for the defendant's story to make sense, what Alexander Jackson told police officers and EMTs and 911 operators is that on June 15th, 2021, this intruder gets into the neighborhood, whether coming from Usher Ferry Road or from Oakleaf Court, up Scarlet Court, whatever that street is, that this intruder makes it into the neighborhood, into the backyard of the Jacksons, and he is not seen by anyone or any cameras. Nothing picks him up. And that in picking this random house that is secured by cameras, but not by locked doors, that he picks the random house with the back door unlocked. Even though on the video camera, the front door is locked, the garage door is locked, all doors are locked in this house, except that basement door. Lucky, coincidental. Then you have to believe that this armed intruder came into this house for one of two purposes. Both of those purposes fit into the definition of burglary, which is why that word's been thrown around and why the defense keeps saying to you, no one said burglary, did they? But when you break and enter into a house with the intent to either steal something, commit a theft, or commit a felony within, that's a burglary. That's where that word comes from. So what you would have to believe as jurors, that this burglar, this intruder, makes it into this backyard, isn't seen, finds the house surrounded by cameras, one coincidentally off, picks the door that isn't locked, and comes into the house to either steal stuff or hurt people. Now, we're going to break into a house and want to steal things, whether that be guns or jewels or money or whatever, and we don't steal anything. Nothing's stolen, nothing's ransacked, nothing's gone through. Okay? Or you're breaking in to hurt someone, but then you don't bring your own weapon. So, after we've made it to the backyard and to the house without being caught on camera, and we find the unlocked door, and we go in with this intent to do one of the two things, there was the proposition that, well, maybe he's in there to steal guns. Maybe he is. or he's in there to hurt people. No weapon. Even the 911 operator, you got shot with your own gun? And then you find this gun, to which the defendant said was unloaded and left on the fireplace from the night before. A gun that the defendant went out of his way to say was his father's and attribute to his dad. It's my dad's gun. It's my dad's gun. I'm not sure where we store it. You store it under your bed because it's your gun. The box that this is stored in is stored under your bed, and it is stored in 2 pieces. The other guns in the house were in the master bedroom or locked in a safe that there was no key to. This gun is the defendant's gun. It's his .22 Browning rifle, semi-automatic. It's his Eagle Scout gun, ladies and gentlemen, that he's comfortable with. In the hospital, he's even explaining how he cleans it and takes it apart because that's the gun that he's familiar with. Box under his bed. So the defendant comes in, and the only in one box, according to the defendant, of ammunition that this family owns for this gun is also sitting out neatly next to the gun on the fireplace mantle, and this burglar or murderer or whoever just loads this gun and goes on a killing spree. And in no specific order, assassinates and executes Sabrina Jackson, assassinates and executes Jan Jackson, goes upstairs, assassinates and executes Melissa Jackson, comes back downstairs with at least 4 bullets in this gun, ladies and gentlemen. The defendant, after hearing all of these gunshots, wakes up and runs downstairs. We're supposed to believe he went out the back door and in, and runs into this intruder and pushes him and wrestles with him and struggles over this gun, leaving only perfect, good quality palm prints on the butt of this gun that they are struggling over. And the defendant gets shot in the foot. Then he says he falls. So after the struggle and the pushing and him getting shot in the foot, he says he falls down. You can picture this in your head, right? That this intruder is standing over the defendant who's laying there bleeding from the foot. Point blank range, like the intruder likes it, right? Like he executed Melissa Jackson and Sabrina Jackson and put 2 in the back of the head of Jan Jackson. He's standing there with the defendant on the floor. And then he just decides, you know what? I have reached my kill quota for the day. I'm going to let this guy live. The one guy who can identify me, the one guy who struggled with me, the one guy who's going to be able to call the police. We're just going to let 1 shot to the foot is good enough for him. We're going to leave that guy alone with 3 bullets left in my chamber. And then I'm going to put the gun down and I'm going to run back out the back door.
You can't fit 3
Nobody's
bullets in
going
a
to
chamber.
chase me. No one who's trained in rifling through the Eagle Scouts is going to pick up that gun and fire any shots in my direction, is not going to hoop and holler for help, is not going to follow me out the back door, nothing. I'm going to put the gun down and I'm going to leave out the back door. That's where the intruder went. Ladies and gentlemen, that makes 0 common sense. 0. Mr. Johnson stands up here and suddenly he's an expert in bloody footprints and void marks, and there aren't any bloody footprints going into that bedroom where the defendant said his phone was. There is blood spatter in there. There is a deep-seated blood spot next to the bed where you see those spatter marks. There's no shell casing in there. There's no shell casing around the other dark spot behind the couch. Both of those areas, and you see them in the photograph, and Investigator Bosenberg testified to, were cut up, and there's no bullet. Do remember what the defendant was playing with when the officers had that oh crap moment and realized that they'd left the defendant downstairs unattended with a loaded gun. When they came back down those stairs, the defendant's playing with a shell casing. Getting shot didn't hurt as bad as he thought he would. The defense, ladies and gentlemen, stood up here and clicked through a bunch of family pictures and accused the state of trying to inflame the passions of the jury. You're smarter than that. They want you to find some significance and some relevance in the fact that when Sabrina and Alexander Jackson were little and they went on a bunch of family vacations, that this family was happy. I'm sure they were. I hope they were. What you don't see in any of those photographs or any pictures that are recent of this family, and you ask yourself what goes on behind closed doors and you don't know. No recent family photos. And witness after witness after witness that the defense put up, they did a good job of testifying about the defendant's character 4 or 5 years ago. The same 4 or 5 years ago, if not more, that you see in these photographs. There aren't recent family pictures of the Jacksons hanging on those walls. The only recent pictures of the Jacksons are them laid out on a cold slab in the medical examiner's office. Because the defendant murdered his family, ladies and gentlemen. That's the only scenario in this situation that makes sense.
She's almost done.
That's the only scenario in this situation that is supported by and consistent with the evidence that was found. This was not some random intruder that breaks in and executes a family that he doesn't know with a gun that he didn't bring with the hope to steal things that are never stolen. Where there's a struggle with a huge man and a tall man, a black man with green shoes wearing all black and a ski mask with gloves on. Makes no sense. The murderer in this case that you're looking for, ladies and gentlemen, is seated right behind me. And that murderer is Alexander Jackson. And I submit to you that when you go back to deliberate this case and you look at the facts and review the evidence and check the cameras and watch them yourself and listen to calls and judge and give weight to everything that you've received in this trial, there is only one conclusion that you as jurors are going to be able to reach, and that is that this defendant is guilty of all 3 counts of murder in the first degree. Thank you.
She's
All
very
right,
good at her
ladies and
job.
gentlemen, at this point, I'm going to read to you the remaining, I believe, 4 jury instructions. Starting with instruction number 36. During the trial, you've been allowed to take notes. You may take
There's
these
a
with you to
lawsuit.
the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Leave the notes in the jury room and they will be destroyed. Instruction number 37. Exhibits have been admitted into evidence.
That wasn't a
and are
warning, that was an
considered along
instruction.
with all
Leave
the
them.
other
They
evidence
will
to
be
assist you
destroyed.
in reaching your verdict. You are not to tamper with the exhibits or their contents, and each exhibit should be returned into open court along with your verdict in the same condition as it was when you received it. Instruction number 38. You may not communicate about this case before reaching your verdict. This includes via cell phone and electronic media such as text messages, email, electronic messaging applications, and any social media platform, including but not limited to Facebook, LinkedIn, YouTube, Twitter, TikTok, Instagram, Snapchat, any other social media applications you may use. Do not research or make any investigation about this case on your own. Do not visit or view any place discussed in this case. Do not use internet or application-based maps or programs or any other application, program, or device to search for or view any place discussed in the testimony. Also, do not research any information about this case, the law, or the people involved, including the parties, witnesses, lawyers, or myself. This includes using the internet to research events or people referenced in the trial. This case will be tried on evidence presented in the courtroom. If you conduct independent research, you'll be relying on matters not presented in court. The parties have a right to have this case decided on the evidence they know about and that has been introduced here in court. If you do some research or investigation or experiment that we do not know about, then your verdict may be influenced by inaccurate, incomplete, or misleading information, and that has not been tested by the trial process, including the oath to tell the truth and by cross-examination. All the parties are entitled to a fair trial rendered by an impartial jury, and you must conduct yourself so as to maintain the integrity of the trial process. If you decide a case based on information not presented in court, you will have denied the parties a fair trial in accordance with the rules of the state, and you will have done an injustice. It is very important that you abide by these rules. Failure to follow these instructions may result in the case having to be retried and could result in you being held in contempt and punished. Instruction 39. When you begin your deliberations, you should select a foreman or forewoman. He or she shall see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express his or her views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. When two or more alternative theories are presented, or where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. It is your duty as jurors to consult with one another and reach an agreement, if you can do so without compromising your individual judgment.
Okay, we in this poll.
Each
We've got
of you
another one
must
coming
decide
up.
the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong, but do not change your opinion as to the weight or effect of the evidence just because it is the opinion of the other jurors or for the mere purpose of returning a verdict. Remember, you are not partisans or advocates. You are judges of the facts. Your sole duty is to find the truth and do justice. Occasionally, after a jury retires to the jury room, the members have questions. I have prepared the final instructions only after carefully considering the evidence presented in the case with the lawyers. I have tried to use language which is generally understandable. Usually your questions about the instructions can be answered if you carefully reread them. If, however, you do find it necessary to ask a question about the instructions, you must do so in writing.
We'll do a poll on the verdict
communicate with you
in just a
without
minute.
first
The
discussing
time.
your questions
Deliberation
and
time.
the potential answer with the lawyers. The court attendant who works with you in this case from now on is in the same position as I am. She will take an oath not to communicate with you about your deliberations. She has not spoken to you during the trial except about the mechanics of being a jury. She will not speak to you when you have retired to deliberate, except to ask you if you agreed upon a verdict and to manage the logistics of your service. Please do not place her on the spot by asking any questions about the instructions or the evidence. Jurors like to know how long each day they will deliberate and whether they will be sequestered. How long you deliberate any day, it's up to you. It's up to you. You will not be sequestered. That is, you'll be free to go home each evening if you deliberate more than one day.
No, the
You
gun
will
could be
stay together
fired
during the
with
day,
partial
including
load
meals.
as far as just a
Finally,
couple.
if you
It
need to
doesn't have to have all
notify
11
anyone
bullets
about the
in there.
time that you will be here, please notify the court attendant, and we will make a phone available to you. Also, if you need confirmation of your attendance to keep peace with your employer, the clerk's office will provide you with the appropriate documents. Instruction number 40, forms of verdict have been prepared for you.
Here we go.
and
These are the charges we get to
attached to
hear.
these instructions. You're a four-person. Each fellow juror will sign the form of verdict, which accords with your findings.
error.
When you have agreed
Found an
upon a
error.
verdict and the forewoman or forewoman has signed the verdict form, please notify the court attendant. All right, ladies and gentlemen, I've read to you all the jury instructions, just a couple of other things. I'm going to send the original back with you. It's signed. It's the same as the ones I've given you, except for the few little typos that we discussed. I've corrected those on the original. There were a couple extra thes that I crossed out and initialed. You'll need to make sure this comes back with the verdict attached with a binder clip to the original jury
That's a heavy
instructions.
poll,
will be the
Sandy.
verdict
That's
forms.
a heavy poll.
There is one form of verdict for each of the three
Let me do another
counts,
one first, and then we might do that one.
of
Okay,
the
Sandy.
forms of verdict has 4 different possible alternatives. All of the exhibits almost all of the exhibits will come back to you when you deliberate. We will provide you eventually with a laptop that does not have any internet access or anything.
80% are yes on the
that will
guilty,
allow you to
20%
view
no.
any of the video exhibits.
Self-defense wasn't
We'll have CDs and you'll be able to watch those.
a defense on this one.
3 of the exhibits I've discussed with counsel. That would be excuse me, 4 of the exhibit, I believe State's Exhibit 155, which is the firearm itself, and then State's Exhibits 172, 173, and 174, which are the live ammunition. We're not going to be sending back with you folks. If for some reason you decide you'd like to view those, simply notify the Terry, and we will make arrangements for you to view those here in open court. All right. Next, we need to select 2 alternates. Before I do that, I'm just going to say we're going to select the 2 alternates. I'll draw their names out randomly. Those 2 folks are going to be free to leave at that point. However, they are still subject to the admonition that I gave you previously. It's unlikely, but theoretically possible that something could happen to one of the 12 jurors who's here, and we would need to recall 1 or more of the alternates. So
I spelled, how long will the jury deliberate?
that's
not
why
with the
you're
jury.
still subject
Sorry.
to the
Messed up the
admonition
poll.
that I've given. Again, don't talk about the case with anybody. Don't form any concrete opinions about this case because you will not have had a chance to deliberate with your fellow jurors. Don't do any sort of investigation about the case, and don't communicate with anybody about the case. I will ask that the
no,
2
Medusa's child, they don't get
individuals that I
copies of that.
select as alternates leave their telephone number with Terry. I will personally call them
The Terry.
once
Terry's got one more
jury
job now.
verdict has been reached. Let them know what the
Lights,
verdict is.
water,
Um,
lunch menu,
try
and
to answer as best as I
calling
can any
alternates.
questions that the alternates may have had, and let them know that they are no longer subject to the admonition that I gave previously. And I'm just going to say it now, before I let the 2 alternates go. Again, I appreciate all of you, how attentive.
Yes,
and
they
how,
are allowed to take notes, not during the
on
opening
time
or closings.
you've been, and that applies to the alternates as well. The alternates obviously have been here for a long time, have heard the evidence. They're not going to be part of the deliberations most likely, and so I just want to let the alternates know I appreciate what they've done to this point. And again, I will call them and let them know the result, and again, try to talk to them as best as I can about anything they'd like to talk about. So with that.
Yeah, the alternates don't get the closure that the we bring out the box.
Fancy thing here. Let's give it a spin.
And it's a rabbit. No, just kidding.
I've selected 2 names out of the 14 that were placed in there. And so our alternate jurors are going.
Okay, they just turned the audio off because he's reading names. Actually, he's pulling out numbers. He's cross-referencing these to the juror names, and the juror names are not allowed to be read. So we'll get audio back in just a second when he's finished announcing that they're off. Yeah, sometimes the alternates
Right.
have to sit there.
So you 2 are
Sound
the
back.
alternates. And again, at this point, you are free to leave your notes. We'll keep those aside so that you can, if we had to summon for some reason, you'd have those available to you, but just leave those on your chair along with your buttons and everything else. And again, just make
55
sure you
days.
leave your phone number so we can get a hold of you. If for some reason we need to call you or need to recall you, or, if not, I can contact you once these proceedings have been completed. Okay? All right. So we'll let you go at this point.
Hey, Denise, we know that he has family up in Oregon. The
And
defendant.
I'm sorry, just one other thing I'll tell you. We did order lunch for everybody already, so you can talk to Terry. If you would like to stick around and get your lunch, we can make that available to you. But just stick around, and Terry will be out in just a minute to talk to you about that and to get your phone numbers.
As soon as she's done, turn off the lights. Paul, will the jury order Chick-fil-A?
All right.
It's
At this
Terry's
point,
choice,
I
I
need to
think, today.
administer an oath to Terry.
Come on, Terry, let's
Please
hear
raise
it.
your right hand. Do you swear or affirm that you will take charge of this jury and keep them together in some private and convenient place, that you will not permit any person to communicate them, and that you'll return the jury into court when they have reached their verdict. Please answer, I do. All right.
Yeah, please
All
say
right,
the right
with that,
thing.
ladies and gentlemen, I'm going to
Dismiss
put you in Terry's charge, and she'll, I believe, return you to the jury room, and it'll take a few minutes for us to gather up the evidence and computer and all those things, but those should be along shortly. All right?
All rise for the jury. Okay, we're now in verdict watch. Yes, lots of rabbits in the box we're pulling out there. Bingo. Let's see. To get pulled as an alternate would really suck at this point. With all the time you've invested, you've clearly got an opinion at this point. You've got some strong feelings on the matter, and then you're just like, "Hey, thanks, see ya," type thing. That was nice of the judge to say, the alternates, when this is all decided, I'm going to call you and talk to you and say, "Hey,
All right, go ahead and have a seat.
here's how it went.
At
This
this
is what's
point-
happening."
Is there any further record to be made about anything on behalf of the state? Mr. Johnson? Sure.
He said yes, but I kind of want to wait till the jurors get out of. So apparently the jury, judge might have been a little hasty there, getting started again. So let me go ahead and close this poll out as well. If you didn't vote, sorry, it's over.
If you want to use your mic too, I appreciate it.
About half of you say it's going to take 2 to 4 hours, and the next highest is more than a day. I didn't say whether it was going to be hung jury or not. Sandy's question is a loaded question. I'm not sure. It's a heavy one. What do you say, Sandy? Would you be willing to do a poll on whether
out of there? So I'll just start.
one would?
Your Honor, we had a bench conference during Ms. Slaughter's rebuttal argument. I made an objection about her using the terms "that's a joke" and "stop it." And then after I made that, she said something was an insult, and I objected to her personal commentary
It's grounds for
on the
mistrial right
case,
there.
and that it was clear that her entire argument was her own personal opinions on things. She never once said the evidence shows or doesn't show. And because of that, Your Honor, we moved for a mistrial.
There it is, mistrial.
Ms. Slaughter, Mr. Scheer?
Obviously, Your Honor, we're resisting the defendant's motion for mistrial. Closing argument is the one place where the state is allowed to be argumentative. The rest of his argument is without merit. We're asking you to overrule and deny it in its entirety.
All right. The only two statements that the court was made aware of during the bench conference, and the third one occurred after the bench conference, but was the
There's a lawsuit.
I think statement referencing a joke and "stop it." Again, I would agree that those statements are questionable, but in the scheme of the overall argument, I don't see that there's any sufficient prejudice or to the defendant that a mistrial would be warranted. So for those reasons and the reasons
Listed before.
articulated by Ms. Slaughter, the motion for a mistrial is denied. Other than that, is there any further record to be made at this point, Mr. Johnson?
Can we approach the bench, Your Honor?
You may.
He's not very confident in the outcome. Come on. Wish we could hear this. The jury is not there.
So, okay, well, all right. Well, let's just go back on the record. So what I'm going to ask is that a representative from, at least one representative for each side, maybe meet with
Terry.
Kathy and to go through the exhibits, make sure we're all on the same page about what exhibits are going back to the jury. My understanding is that I think the record reflects the defendant had to scan, counsel for the defendant had to scan in some of the exhibits. Some of them may not be here right now. They need to get here quickly. And so we can send those back to the jury. But before we do, again, I think the attorneys need to conference and make sure there's no disputes about what we're sending back. If there are, let me know and we'll address it as needed. And then I'm just going to ask for phone number, how I can get a hold of everybody, and we'll call if there are questions and from the juror or when we get our verdict. I will email both of you, both sides, kind of the stock end of the day instruction that I give to jurors, assuming we get to that point, but just so you guys have a chance to look at it. I'm assuming you've seen those instructions in the past. Anybody anticipate any issues with an instruction like that, Ms. Slaughter, Mr. Johnson? But I'll email it to you here, so if there is any issue with it, you can let me know. But otherwise, I'll plan on signing that and getting it to the jury around 4:30 today. Again, if we get to that point. And if we get to that point, I'll probably just call both sides, or send an email to everybody, I guess would probably be easier, and let them know that the jury's gone for the day and we'll be resuming tomorrow. But if anything else happens, obviously, I'll give you a call. All right?
Okay, now I think we're off the record. We're now in verdict watch. I don't know how much notice we're going to get. The judge didn't indicate how long he was going to. He hasn't really been playing to the television cameras very well. So it might just be, jury's in, everyone run. So I don't know how much heads up we're going to get. Did he miss anything? Just the closing arguments, Christy. We're in verdict watch right now. The jury just left. They're shortly going to have all the evidence with them. They're just putting it together right now. Have a bad feeling about the defense lawyer. Yeah, that was yes, I think he was right to object when he did, but I don't know. I think they're going to appeal on that. He said tomorrow. Yeah, he did talk about having extended deliberation, so he anticipates that it's going to go more than one day. Where are we at with Murdaugh as far as the jury? Are we down? I think we're down to what, 120 people. Let's see what we've got here. Trying to see what the latest is. We want to be able to follow that trial as soon as it starts, but I want this one to be done before Murdaugh starts. So, oh, look at that. The kind hand on the shoulder. What is she wearing? Is that like a poppy flower or something? Are we buffering now? Did we drop? Can't tell if it's working out. Murdaugh's to start on Monday, supposedly. That'll be good. Hello, Ivan. Good to have you here. I had the closing arguments on in the background. It was pretty good. I will say the prosecution, that lady does a great job. It is normal to ask for mistrial. They've asked for mistrials or summary judgments at all the normal times. That's good work by the lawyer. Are we? It says the feed's perfect, but my stream's dropping completely. I'm not sure what using tornado located east over Katy, Texas, moving northeast at 50 miles per hour. This is pretty much the theme of the day as this is sort of sweeping across the country. I think actually there's even a chance that I can get snow here where I'm at later on in the week. And I'm in North Carolina on the East Coast. Georgia says morning, they should be back. I would appeal, especially since the judge agreed the comments were questionable. Yeah, that it gave him some, that's on the record that he says the comments were questionable, but he thinks it's not so prejudicial. I think it does. The fact that it was the very last thing the jury heard and they were questionable, that you might have a mistrial from that. Murdaugh's still doing jury selection. I was just trying to see, they started with 700 potential jurors. Let's see. We're told evidentiary hearings could start as early as this afternoon. That's like a pretrial type thing, or it was a motions hearing in Murdaugh trial to start about 1 p.m. So if they seated a jury then? Might check this out. Let's see. 37 minutes ago, it says there will be about, this is from Andrew Davis, by the way, Andrew from WSAV TV. There will be about 120 people in the final jury pool. They will reconvene tomorrow looking for 12 jurors and 6 alternates. Defense and prosecutors will be able to strike between 15 to 20 people to keep them off the jury. So it's just a hearing this afternoon. They're going to continue, probably seat the jury tomorrow. Fourth jury panel consisted of 79 people. Not everyone at this time had heard of the case. That's good. 3 people were either friends or related to Curtis Eddie Smith, perhaps a witness or a victim. No, witness. So that case is starting to heat it up. We're getting closer. Congrats on your new subscribers. I haven't even been able to see. I can't see my own channel right now. This has been a frustrating day for me technology wise. Yes. That's awesome. 5,555 something is what I'm showing. The technology has not been working well for me today. As you can see, I've had to pull apart my studio, and this device might not be working. My internet's not working the way it's supposed to. So we had to sort of piece it together and make it run and hop along. I've got to do some testing. AJ's got a job interview. She's got stuff to do. I'm going to let you guys go for lunch, and we're going to take a little break. It's been fun. I know it always gets a little more heated in here towards the end of the trial as we sort of solidify our positions on where we stand. What about subject matter jurisdiction? We've crossed that bridge already in this case. But yeah, towards the end, it sort of gets a little warmer. I appreciate everybody staying civil and just sharing your opinions. Thank you very much for all those. We'll see what the jury thinks now. So they're underway. We'll be watching for that. I'm going to try to do some testing during lunch. I think we're going to have a little bit longer lunch because the jury gets lunch and then they start deliberation. I don't think they start deliberations and skip lunch. So these evidentiary hearings, a little miss for the Murdaugh trial, this is going to be important because this is, I think, going to have to do with some of the blood spatter evidence on the shirts and things like that. This is going to be very important for the case. It's considering how much circumstantial evidence there is. If some physical evidence is not allowed in, it could have a significant impact on this Murdaugh trial. So that'll be fascinating to hear. Thank you all for being here. Lil Miss says, I'm short 500 starting in November. People keep stealing from me and you haven't tackled them yet. Thank you all for being here. I want to thank all the mods. You guys are fantastic. We're going to come back, might pick up some of the Murdaugh hearings this afternoon. We might start with that as we just sort of get up to speed and sort of learn who the players are. There are a lot of attorneys in this courtroom. So it's going to be interesting. There's a lot of information and so much at play. It's going to be a fun one to follow. It'll be a long trial as well. So let's see. Thank you all. Thanks for being here. I will say that those who are new here, welcome. I hope you found a place that you can enjoy and really, sort of feed your true crime addiction in an environment that's fun and friendly. If so, I would love it if you could subscribe to the channel, ring the bell, and join us. We do go live every morning at 9 a.m. and follow court cases across the country as they happen, and breaking news as well. Occasionally we do some police chases, a little bit of arraignment videos, just anything sort of connected to true crime. But thank you all for being here. I'll close with the music we normally do because it's one of the few things that is working. Thank you all for being here tonight. When you go home, hug the people you love, smile at somebody, make the day just a little bit better. And until we go live again after lunch, which we'll probably be watching Murdaugh, waiting for a verdict watch on this trial. Please stay safe. Thank you all for being here, for your patience. There's a lawsuit for sure. We'll see you guys. Have a good one.